Good afternoon, everybody. I welcome you all to the 15th Medico Legal webinar. I am a Maharashtra State Medico Legal Cell. To start the program, first I would invite the Indian Medical Association Maharashtra State Secretary, Honorable Secretary Dr. Pankaj Bhandarkar sir, to start the session. Over to Dr. Pankaj Bhandarkar sir.
Thank you, Dr. Ashok Shukla. Good afternoon, everybody. I welcome you all on behalf of IMA Maharashtra State for this 15th in the series of medical legal webinars continuously organized by IMA Maharashtra State with the support of Mira Binder branch. So at the outset, let me thank Dr. Divedi and Dr. Mehra. They are the president and secretaries of IMA Mira Binder branch. Friends, today we have not only one but 5 speakers who are going to enlighten us on the various interesting topics. We have with us Dr. Shivkumar Utture, President IMA Maharashtra State. We have with us Dr. Jose Kapadia, immediate past President of IMA Maharashtra State. I welcome them all. We have excellent speakers today. Our own speakers are also there. We have Dr. Jayant Naurange. We have rising star of IMA Maharashtra, Dr. Dinesh Thakre as a speaker today. We have Shailesh Mehta, Dr. Jitendra Sharma, Dr. Pinky Shah, and Mr. Dipen Mehta as the speakers. I am sure the lectures will be very interesting. We have as a host Mr. Sanket Barle and Rajan Sanketi. I welcome them all. And I think without wasting much time, I hand over to Dr. Shukla for further proceedings. Dr. Shukla, over to you.
Yeah. Thank you, sir. Thanks for that kind introduction. And we will directly go to the talk today. So kindly, Dipin, you can show the first slide. As the ongoing programs, we are trying to not only highlight and help us understand the different acts and the different medical legal issues which can help us, empower us, and give us knowledge and also protect us. It is like creating a life-saving jacket, a medical legal life-saving jacket to our members so that they become immune from future litigations, or even if the litigations come, it works like a bulletproof jacket so that our members are protected. To start with today, the first topic, which is going to be not only discussion about the act, we are also trying to understand and analyze the act, whatever amendments have been made, and whether we can suggest more amendments to reduce the harassment to our doctors. So the first topic is critical analysis of provisions in PCPNDT Act 1994 resulting in harassment of guiltless doctors and suggested amendments. Today's speaker is Dr. Dinesh B. Thakre sir. He is a postgraduate medical qualified degree as well as LLB, a legally qualified doctor. He is a multifaceted and a multi-talented person. He has done in MA journalism. He is BA English literature, master training, NABH, pre-accreditation entry level, and the new thing, member steering committee of World Medical Association, associate membership. So we are very happy that IMA is going not only at national, it's at international level. It is recognized at world level by all medical associations and medical brotherhood. He is also a director of IMA Hospital Board, IMA HQ, Vice President of Indian Medical Association Maharashtra State Branch, and President-elect of IMA Amravati Branch. So over to Dr. Dinesh Thakre.
Thank you, Dr. Shukla sir. So greetings from IMA Headquarters Standing Committee for Medical Legal Cell. This committee has some objective. I represent this committee as a member. The objectives are to impart basic medical legal knowledge to IMA members, to train IMA members to be ethically and legally correct in daily practice. Third objective is to boost confidence in IMA members to face any medical legal situation in routine practice. The slogan of our committee is be informed, be empowered, be vigilant. This is our logo. Today's topic is critical analysis of provisions in PCPNDT Act 1994 resulting in harassment of guiltless doctors and suggested amendments. While pursuing LLB, I had submitted a legal research paper as a part of my practical examination on this topic. My guide was Dr. Varsha Deshmukh, Assistant Professor, LLM and PhD in Law. Dr. Ravi Wankhedkar, our past National President and Treasurer of WMA, and renowned OBGYN from Amravati, Dr. Ashwini Kumar Deshmukh, also guided me a lot. So, to start with, what is the reality of society? The mindset, which is responsible for sex determinations and feticide. So, this is the quote: born to rich parents, this boy is so lucky. Born to rich parents, this boy is so lucky, exclaimed the neighbors. Somewhere in heaven, 3 unborn sisters cried. This is the reality of our society. We have to face it. So, abstract of the paper was the Prenatal Diagnostic Techniques Act 1994 was enacted to curb female feticides, but could not produce expected results. Female feticide is done out of a mindset grown in response to customs of society. Rather than providing measures to change social mindset, this act penalizes doctors who can detect sex of fetus and adversely restricted use of ultrasonography in diagnosing and monitoring other diseases. While targeting doctors, some provisions in Act cause harassment of guiltless doctors and defame them. Hence, amendments are needed in the Act, which will serve the purpose of the Act as well as stop harassment of guiltless doctors. Following was the sequence of the research study. Firstly, the provision in the Act or the rules. Then, what is a lawmaker's view or what may be lawmaker's view. Then, what may be doctor's view. And then, the suggested amendment. Friends, there are 28 provisions which cause harassment of numerous guilty doctors in this Act, in Precipitated Act. There are some good provisions also to help to curb the sex discrimination. But looking at overall approach of lawmakers while amending old laws and enacting new laws, I say, मेरे जज्बातों से इस कदर वाकिफ है मेरी कलम, मेरे जज्बातों से इस कदर वाकिफ है मेरी कलम, मैं इश्क लिखना भी चाहूँ तो भी इनकलाब लिखा जाता है, मैं क्या करूँ. So coming to the first provision, it is the regulation of prenatal diagnostic techniques, section 4. It provided that person conducting USG on pregnant woman shall keep complete record thereof in the clinic in such a manner as may be prescribed, and any deficiency or inaccuracy found therein shall amount to contravention of provisions of section 5 or 6 unless contrary is proved by the person conducted with such USG. So shall means compulsory. So any deficiency found therein shall amount to contravention. There is no scope for should or maybe. Lawmakers use that the doctors conducting sonography on pregnant woman shall keep all records correct and up to date. This is the lawmakers view. It is presumed that doctor indulged in sex determination is most likely to fail to maintain accurate record. This is their presumption. And doctors use that guilt cannot be presumed merely on the basis of clerical errors, which are bound to happen during normal professional working. You all will agree with this. There is no nexus of the presumption with the objects of the act. This presumption and the object, there is no nexus. Rather, a culprit will either never maintain any record or maintain it highly meticulously. A small student can also, school-going student can also understand this, but why the government is unable to understand. And what may happen with some authority when she or he visits the real culprit? What is the reality? ये बंद कराने आए थे तवायफों के कोठे, ये बंद कराने आए थे तवायफों के कोठे, मगर सिक्कों की खरन देखकर खुद ही मदरा कर बैठे. This is the thing happen when some authority visits the real culprits. So what's our stand? Doctor's stand is that no person should be presumed guilty if few errors are made in the process of record keeping, since he is only helping the authorities by maintaining such record, right? Such a single case of not a single case of female feticide has been discovered on the basis of record keeping till now, and it violates constitutional right to livelihood, being an unreasonable restriction on the profession. In reference to section 4.4 and 5, the relative present in the procedure room disturbs the doctor and pressurizes for disclosing sex of the fetus, which may lead to clerical error. Or the so-called relative or the patient herself may be a person who is able to identify the sex of the fetus by observing the display or process of procedure going on. This is in respect to the section number 4.4, that is, no person including a relative, husband or pregnant woman shall seek or encourage the conduct of any prenatal diagnostic techniques on her except for the purposes of specified in clause number 2. So according to this section, the relative present in the procedure room disturbs the doctor and pressurizes for the disclosing sex, and he himself may be capable of identifying the sex. So our suggested amendment is that to the first section we were discussing about, provided that the person conducting USG test or procedure on a pregnant woman shall keep complete record thereof in the clinic in such a manner as may be prescribed. But we want that the lawmaker should delete the further sentence. What is that sentence? And any deficiency or inaccuracy found therein shall amount to contraventions of provisions of section 5 or section 6 unless contrary is proved by the person conducting such a certificate. In simple words, we want to say that the error in record keeping should not be equated with the sex determination. Now we want one more suggestion, amendment, that is add number 6, no person including a relative or husband of a woman shall remain present in the procedure room during the conduct of any prenatal diagnostic techniques except lady staff and another doctor specially called for the purpose. There shall be no other display of the procedure going on except visible to the operator, lady staff and another doctor especially called on for the purpose. This amendment should be added. Now amendment number 2, section provision number 2, which is causing problem, that is section 17.4. The appropriate authority shall have the following functions. What are they? First, to grant, suspend or cancel registration of the center, to enforce standards prescribed for the center, to investigate complaints of breach of the provisions of this act and the rules and take immediate actions. All these are the functions of the AAs. Next function is to seek and consider the advice of the advisory committee on application for registration and on complaints for suspension or cancellation of registration. Next function is to take appropriate legal action against the use of any sex selection technique by any person at any place, suo moto or brought to its notice, and also to initiate independent investigation in such a matter. All these are functions. To create public awareness against the practice of sex selection or prenatal determination of sex, to supervise implementation of the provisions of the Act, then to recommend to the CSB and state boards modifications required in the rules in accordance with the changes in technology or social changes. So note this point. This is also a function of AA. There is some disturbance. Admin, please mute the other. Okay. So this is important function to recommend to the state boards modifications required in the rules in accordance with the changes in technology or social conditions. Means whatever we are wanting, it is in the hands of appropriate authority also. Next function is to take action on the recommendations of the advisory committee made after investigation of complaint on suspension or cancellation of registration. So I deliberately enumerated all the functions so that those who are not much aware of the Act should come to know about the functions of the AAs, because in the next 30 minutes we will be talking much about the role of AAs. Lawmaker, what is the lawmaker's view on this? All these functions, the AA should be empowered enough to take action so as to enforce provisions in the Act effectively. Fine, no issue. Doctor's view, taking action on an innocent doctor, ruining his practice and tarnishing his image without sufficient chance to put up his side or without sufficient evidence is a gross injustice. I think everybody will agree with this. So what is the amendment? add to the above functions, all your functions we have read, add to it that provided that AA has sent show cause notice to the accused, investigated the case, and there is a strong prima facie evidence of the offense alleged, then only the A should go further. Now the provision number 3, cancellation or suspension of registration. This is again a big issue. Lawmakers' view is that the appropriate authority should be empowered enough. The appropriate authority should be empowered enough to take action so as to enforce provisions in the Act. Fine. Doctors use that this will give uncontrolled powers to the AAs and may cause harassment of medical professionals, clinical owners, particularly where the alleged violation is minor in nature. So what is important here is the minor in nature, because in this Act, even minor violations are also punished very strongly. How we can see? So to continue the cancellation or registration of registration, we want lawmakers to add number 4, this amendment number 4. No registration shall be suspended under subsections 2 and 3 for more than 90 days if there are no allegations of violations of sections 3, 3A, 3B, 4, 5, 5, 6 and 22 against the clinic. These are the major sections. So this is how government behaves with us. The boy is trying to fly a kite with so much difficulty, or his mama is saying to him, "Agar gir gaya to टांगे तोड़ दूंगी." When we are trying hard to follow such draconian, unwarranted provisions that we will see, the lawmakers and concerned authorities go on intimidating us of dire consequences if we err even a little. Example is equated no signature on report with the sex determination. They say that no signature of on report is equal to sex determination. 4th provision, it is section 23(1). Any gynecologist or registered practitioner who owns a genetic counseling center like that and renders his professional services to such a center, whether on honorary basis or otherwise, and who contravenes any of the provisions of this Act or rules, or any of the provisions made thereunder, shall be punishable with imprisonment for a term which may extend to 3 years and with fine, which may extend to 10,000, and to add on any subsequent conviction with imprisonment which may extend to 5 years and with fine to 50,000. So subsequent conviction has more punishment. So what is the lawmakers' view naturally is that punishment should be sufficient enough to deter others from violating provisions of the Act. Doctors' view, only major offences like having a clear contravention with the objects of the Acts in order to curb female infanticide, only such major offences should be punishable under this section. Sometimes such an act is done unintentionally or is caused because of ignorance or misunderstanding or a clerical error. Hence, graded punishment should be given. So what is the amendment? We want to change in the amendment. Now how the new amendment will read that any medical practitioner like that employed in such center, etc., and who contravenes provisions of sections 3, 3A, 3B, 4, 5, 5, 6 and 22 or rules made thereunder shall be taken. These are the heavy sections we are read. Taking into account intention, severity and frequency of the act, be reprimanded or be warned or be punished with the imprisonment. First he should be reprimanded, then he should be warned, depending on what the intention, severity and frequency of the act, and then punished with the imprisonment for the term whatever it was described in the original section. Now next is 5th provision. It is section 23(2). The name of the registered medical practitioner shall be reported by AA to the State Medical Council concerned for taking necessary action. And this is important, no? The name of the registered medical practitioner shall be reported by the AA to the State Medical Council concerned for taking necessary action, including suspension of the registration if the charges are framed by the court. So only the thing that charges are framed by the court, they say that the name of the registered practitioner should be reported to the medical council for suspension and till the case is disposed of, and on conviction for the removal of his name from the register. When as soon as the court charges are framed, his registration will be suspended, and after 10 years, 12 years, 15 years, when he will get convicted, his name will be removed, and if he is not he is acquitted, then the suspension will be revoked. So for the use of after 10 years and 12 years. So naturally their view is that lawmakers feel that punishment should be sufficient to deter others like that, and doctors feel that this section is also being used against those facing trial on clerical errors. That is the important thing, and therefore it is necessary to mention subsection 1. Nobody can be deprived of his livelihood merely on the basis of framing of charges, since he does not receive any compensation for the losses suffered by him if he is ultimately acquitted by the court. But no one is listening on this. The medical practitioner should not be deprived of the means of livelihood unless and until the offense is proved. It takes years for the case to be decided by the courts. Even if he is acquitted after that, his life is already ruined for no fault of him. The period of 5 years for the first offense and permanent removal for the second offense is without any justification. So we want change. The name of the registered medical practitioner shall be reported by AA to the State Medical Council concerned for taking necessary action. What action has to be taken? That the State Medical Council decide. Therefore, delete the provision that including suspension of the registration if the charges are framed by the court until the case is decided, disposed of, and this much provision should be deleted. By finally decided case for the removal of his name from the remaining of the section is 7. So provision number 6 is section 28. Cognizance of offences. Now how the offences are taken cognizance. Lawmakers use that again the punishment should be sufficient. So there is a harsh cognizance. How? Let us see first doctor's view. Trying a doctor unless there is a strong prima facie evidence ruins the life of the doctor if not found guilty. So it is a waste of precious time of the court. Acquittal takes years and he cannot practice, thereby losing livelihood. So there should be some rational things in during taking cognizance of the offences in a PCP entity. So we suggest to add subsection number 4 that no court shall try any suit or issue under this act unless and until there is a strong prima facie evidence. Is the demand any high? It is a rational demand. Supporting, so unless and until there is a strong prima facie evidence supporting allegations of violating any provisions under this act. Similarly, media publicity of such trial cause irreparable damage to the reputation and image of the center and the doctor, and also affects the livelihood of the doctor. It is true. So we want to suggest one more amendment to add 28A, that is prohibition on media not to publicize any raid or inspection until convicted. No media or person shall in manner publicize any raid or inspection or inquiry of the center unless and until convicted by the court. I'll go to provision number 7. Section 31. If the AA has reason to believe that an offence under this act has been or is being committed at any center, any officer, such authority or any officer authorized thereof in this behalf, subject to such rules as may prescribe, enter and search at all reasonable times with such assistance, if any, as such authority or officers consider necessary. So in simple words, that the authority and or the officer authorized by him can enter and search your clinic at all reasonable times. Examine the record, register, document, book, pamphlets, advertisement, or any other material object found therein. And not only this, he can seize and seal the same, if such officer has reason to believe that it may furnish evidence of the commission of the offence punishable under this act. Now it is at all the whims of the officer who is reading. The lawmaker says that AA should be empowered enough to take action so as to enforce the provision of the act. This is the lawmaker's view. What is doctor's view? Machine is sealed for paperwork errors or unless there is strong prima facie evidence ruins life of the doctor, even if not found guilty at the end. It is wastage of time of court. Acquittal take years and he cannot practice, thereby losing his livelihood. Because no one thinks about this. So we suggest an amendment that please add the following provision. Please add that provided that this section will not be applicable to a machine in case of paperwork errors or till such order from the court in other cases. So this should be exempted when there is a problem in paperwork. Now the 8th provision. Now this is the rules 2012. Intimation of changes in employees, place or equipment. This is the dreaded provision which presumes that you are a hardcore criminal. Every genetic center or clinic for that matter shall intimate every change. Okay? Intimate every change of what? Employee, place, address and equipment installed to the AA at least 30 days in advance. You must know today that the employee will be changing after 30 days. It's okay with place or address, but how you can tell today that the employee will be changing after 30 days? He may resign at any time. So they expect that at least 30 days before you should tell the expected date of such change and seek reissuance of certificate of registration from the AA with the changes duly incorporated. Whatever changes they will incorporate and they will give you another certificate. Will it give you free of cost? So lawmakers use that to check the misuse of machine during the change. So what a laughable. Doctor's view is intimation of change of employee other than medical practitioner is unwarranted and is without any nexus with the objects of the act. In case of machine breakdown, change of machine should be allowed immediately as it is the question of livelihood of the sonologist. So we suggest an amendment. We suggest a change in 26. That every center shall intimate to appropriate authority, right? First, change of place and address 30 days before. We agree with that. Change of medical practitioner 7 days before. Please do it 7 days. Change of machine because of breakdown or at least seven working days. So instead of 30 days, make it 7 days. And add explanation to the subsection 3 that the machine can be used after due intimation to the appropriate authority. After due intimation to the AA, the machine can be used. The endorsement shall be responsibility of the AA to avoid the misuse, as they say. 9th provision in the rules. Ensure that no application of fresh registration or renewal of registration is accepted if any case is pending in a court against the applicant for violation of any provision of the act and the rules made thereafter. So again, they feel that punishment should be sufficient for the hardcore criminals. Our view is that there are 2,350 cases and around 90% are for the paperwork errors. The cases are moving from JMMC, District High Court to the Supreme Court. It will take decades for a final verdict. Till that time, the center shall be allowed to function. Rather than making an unreasonable rule, the focus should be on speedy judgments from the courts. Nobody talks about that. So we suggest an amendment, the change in 27. The same amendment we suggest to change in 27. Ensure that no application for fresh registration or renewal of registration is accepted from the applicant if he is convicted, not charges frame now. He is convicted with the imprisonment under section 23 and during the imprisonment. That is acceptable because he is convicted. We don't support convicted criminals. Now provisions 10. Any person, it is from section 22(3). Any person who contravenes subsection provisions of section 1 and 2 shall be punishable with imprisonment for a term which may extend to 3 years and with fine which may extend to 10,000 rupees. Arvind? Thank you. Again, the same punishment should be sufficient. Okay. What is our view? Sometimes such an act happens unintentionally and is caused because of ignorance or misunderstanding or clerical error. Hence, graded punishment should be given. That is our say. So we want to suggest amendment, that is change in 12. Any person who contravenes the provision of subsection 1, taking into account intention, severity, frequency of the act, be reprimanded, warned, or punished in imprisonment. Again, there should be graded punishment. Now, provision number 11, that is penalty for contravention of the provisions of the act or rules for which no specific punishment is provided. Sir, just a minute. So this is very important section. Let us read it. Whoever contravenes any, the word important is any, of the provisions of this act or any rules made thereunder for which no penalty has been elsewhere provided. Now please appreciate that there is much penalty provided in the act. In the coming sections we will see, in provisions we will see that there is much more punishment. But still it says that in case there is no penalty has been provided elsewhere in this act, he shall be punished with imprisonment for a term which may extend to 3 months or with fine, or which may extend to 1,000 rupees or with both. And in the case of continuation of contravention of such minor provisions, with an additional fine which may extend to 500 rupees for every day, 500 rupees for every day, during which such contravention continues after the conviction of first such contravention. Now who will decide that the contravention is continuing every day and you are giving 500 rupees per day? To whom you will give? I mean, who will decide? So next is again the lawmakers view is same, that punishment should be sufficient. Doctor view is again the same, that only major offences where there is a clear nexus with the objects in order to curb the objects of the act in order to curb the female feticide should be punishable under this section. Sometimes again such act is done unintentionally and because of ignorance and misunderstanding or clerical error. Hence graded punishment should be given. That is our demand. So we are suggesting changes in 15. What changes we are suggesting? Same, that taking into account the intention, severity and frequency, be reprimanded, warned and punished. The whole section is same. Only we want to say that first reprimand, first warn and then punish, and not only every, but taking into account the intention and severity. If you on the first place, prima facie you feel that there is a high severity and there is a much the doctor is a frequent violator, then you can punish in the first instance only. But first take into the account, no. Now the section provision 12. Where we will be saying says 28th provision. So don't get tired. This is only 12th one. Provision section 27. Offense to be cognizable, non-bailable and non-compoundable. Right? Offense to be cognizable, non-bailable, not compoundable. Every offense under this act shall be cognizable, non-bailable and non-compoundable. Every offense, mind the word, every offense. Lawmakers view again the same. What is our view? Again the same, that it should be the graded punishment because it may occur with misunderstanding, with clerical error, right? So civil offences should not attract criminal punishment. It is the principle of the law, but it is violated here. Offences under section 25 and other minor offences shall not be put under this category because they are a very minor one. So we suggest a change in 16, that every offence punishable under 23, that is the severe offences, shall be cognizable, non-bailable and non-compoundable. It's okay. Provision 13. Now about appeals. Now here the natural justice of appealing to the proper higher authority is curbed. See how. Anybody agreed by the decision? Anybody agreed by the decision of the AA at sub-district level may appeal to AA at district level within 30 days of order of the sub-district level AA. Anybody agreed by the decision of the AA at district level, appeal to the state level within 30 days, right? Each appeal shall be disposed of by the district AA or by the state AA as the case may be within 16 days of its receipt. If the appeal is not made within the time as prescribed above, the AA may condone the delay in case he is satisfied with the appellant. So these are the general provisions. So what is the lawmaker's view in that? That they want to provide a chance of appeal to the aggrieved doctor at various levels. Now what is our view? What if the given authority do not dispose the appeal in time-bound manner? 60 days are given, 30 days are given, then 60 days are given, and if the authority do not dispose the appeal in 60 days, what next? If he will take 1 year, 2 years, what next? What will he do? No person should be made to suffer for someone else's fault, that is A's fault. In addition, there must be a suitable mechanism for complaints against misuse of powers by some A's. Should it not be there? Actually, it's so strict for us. Why should not lawmakers ensure that there will be no misuse of the powers? So we suggest amendment that add a new sub-rule to 30, number 5. If an appeal is not disposed within 60 days due to lack of time by the AA, it shall be presumed that the appeal has been decided in favor of the appellant. There are such provisions in other acts. Add a new rule, Rule 20. If anybody aggrieved by the action of the concerned AA, other than that taken under 20, may file a complaint to the district level AA for initiating action against concerned AA. And such complaint shall be disposed within 60 days. The complainant shall have the right to file a complaint in the competent court, because you are saying that there is no appeal to court. Highest level is state AA. We want to go to court. So we should have right to file a complaint in competent court under section 25 if not satisfied with the outcome of the complaint of the complaint to the district area. Section provision number 14, section 21, appeal. Again, the center may within 30 days from the date of receipt of the order of suspension or cancellation of registration passed by the AA under section 20 prefer an appeal against such order to central government. You can go to central government where the appeal is against the order of central AA, right? And the state government where the appeal is against the order of state appellate authority in the prescribed manner. So you can go to central government against central AA, you can go to state government against the state AA, but not to the court. This is injustice. So what is their view? That one level of appeal to the respective government is sufficient. So you are the boss. You are above the court. Why don't you want to give us a natural justice, natural ways of justice that you provide to the hardcore murderer? Are we above the murderer? More than a murderer? Hardcore than a murderer? So doctors use that it is necessary to ensure the protection given by Article 40 of the Constitution. That is, everybody is equal before law and law is equal for everybody. So whether it is only to write in the Constitution, not to follow. Hence, all levels of appeals available to any general citizen of India, including hardcore murderer, hardcore rapist, should be available to the accused doctor. What is wrong in that? So we suggest an amendment, add to 11 that, provided that no person who is vested with the right to appeal as per section 21 shall be deprived of levels of appeal provided at the level of district AA and state AA as per the rules. Now the provision 15. That is the rules 2004. Take immediate action of filing appeal, revision or other proceeding in higher courts in case of order of acquittal within a period of 30 days, but not later than 15 days of receipt of the order, the acquittal. Now, they have ordered this is the order to the AA that you take immediate action for filing appeal, for filing revision and other proceeding in higher courts. Means if A don't want to do then what? But no, this is the function of they are given to the AA. The AA should be empowered enough to take action. So the AA himself can proceed further. This rule forces the authorities to file appeal even in those cases where the order of acquittal is legal without any defect. Still, the AA is enforced by the law to file and revision, at least revision, not appeal. So we suggest that delete this rule. This is unnatural justice. This is unnatural injustice. Under all sorts of stress and time management, dear friends, when you start keeping currently demanded record, they order us to keep some more record. That is the khasiyat of the government or the authorities. So I can say this sentence for such a situation. कर्फ्यू में भोजन बांटते हुए उस दानदाता की आंख में आंसू आ गए. कर्फ्यू में भोजन बांटते हुए उस दानदाता की आंख में आंसू आ गए जब पैकेट लेते हुए वो शख्स बोला, भैया अगली बार खर्रा भी लेते आना, दुआ लगेगी. Going to next provision 16. An application for renewal of certification of registration shall be made in duplicate in Form A to AA 30 days before the date of expiry of the certificate of registration. Acknowledgement of receipt of such application shall be issued by the appropriate authority in the manner specified in Rule 2 of Rule 4. What is their view? To ensure continuation of registration of the center. This is the way to ensure continuation of registration of the center. Any event that will happen after 5 years in future is beyond normal human capacity to remember. The subordinate staff of the AA can easily send a notice since they have all the information in their software. Because you are otherwise giving so much a punishment now. So on your side you should do something. Besides, the penalty for forgetting to renew timely entails prosecution under section 23(1). That is heavy prosecution, and therefore a warning or notice is must. Since the lapse of memory or overlooking is totally unintentional and completely inhuman. So we suggest amendment. Add in 23. Provided that the AA shall send notice to the concerned clinic by registered post at the registered address at least 90 days before the expiry of such registration, informing the owner of the clinic the date of expiry of the registration. Going to next provision 17. Each medical practitioner qualified under the Act to conduct ultrasonography in the clinic shall be permitted to be registered within a maximum of 2 such clinics within the district. Only 2 clinics. The consulting hours for such medical practitioner shall be clearly specified by each clinic. So they say that lawmakers say that this is to ensure the delivery of quality of services. So what doctors say? The restriction of 2 places has no nexus with the objects of the Act and is therefore an unreasonable restriction on the right to livelihood. Specifying time, they want you should put up the time there, specific time. It deprives the seriously ill patients of emergency services and has no nexus with the objects of the Act. So we suggest that change in 22, that every registered medical practitioner qualified under the Act to conduct USG shall conduct such scan only when the information of his employment in such a clinic has been duly sent to the concerned AA and has been duly acknowledged by the AA. So there should be no restriction on the number of centers. Now, provision number 8. The AA shall, after holding an inquiry and after satisfying itself that the applicant has complied with all the requirements of the Act, all the requirements, and these rules, and having regard to the advice of the advisory committee, we will see who is there in the advisory committee in this behalf, renew the certificate of registration as specified in the Form B for a further period of 5 years from the date of expiry of certificate of the registration that is granted earlier. So what lawmakers say that it is to ensure enforcement of provisions in the Act and continuation of registration of the center. So sweet. What is doctor's view? A medical professional who has put his life into his profession and invested considerable sum in the equipments, etc., cannot be subjected to the whims and fancies of the AA, particularly when his record is flawless. So add in 24 that provided that the procedure outlined in Rule 8.2 shall not be required in cases where no departmental or legal proceeding have been initiated during the period of previous registration if his records were flawless within last 5 years, please relieve him of all these obligations. Right? So 19, all the AAs including all the appropriate authorities, including the state, district and sub-district notified under this act, inter alia, shall observe the following conduct of accountability. Now this is accountability for AAs. What are they? We'll see. First is, they should obtain prior sanction or approval of the government of India for any resolution concerning the implement of the provisions of the act. Is this happening? You must be having some experiences about this. Lawmakers use that the appropriate authority should work uniformly and no resolution inconsistent with the provisions of the act shall be passed. Very good approach. Now this is the way some AAs are putting the boards and things. You can see this video. The concerned appropriate authority.
साला ये बोर्ड देखकर ना दिमाग हिल गया मेरे। ऐसा ऐसा कैसे हो सकता है? हिंदी में थूकोगे तो 500, अंग्रेजी में थूकोगे तो 250। ये लोग पता कैसे लगाएंगे आदमी हिंदी में थूका या अंग्रेजी में थूका?
So the concerned
ये बोर्ड देखकर ना दिमाग हिल गया।
The concerned appropriate authority must obtain prior sanction or approval of the government of India for any resolution concerning the implement of the provisions of the act. We agree. They should stop. So what is doctor's view? At present, new orders are issued by all levels of AAs without duly notifying and without giving any reasonable time frame for their implementation, except some respectable AAs. There are very few nice respectable AAs who are very cooperative and understand the plight of the doctors. So we suggest an amendment to add to 29, provided that a new regulation shall be notified to the registered clinic by register post, giving at least 30 days time for implementing such regulation. Doctor has so many work, so at least give him 30 days to start any new things. Now see this cow. Just because this cow has power, she is wants to play football, and he is not allowing experts to play their game. She feels that she is an expert because she has power, and how she is behaving. There is a football below her hands. Because she has a power, she has a nuisance value. She wants to play football. She is not allowing experts to do their job. She is trying to play football. So you have power does not mean that you are expert. This is long, we'll stop. So provision 20, how it is applicable. When appointed for any part, any post, I think, any part of the state or the union territory of such other rank as the state government or the central government, as case may be, may deem fit. So to explain, lawmakers use that any officer of any rank is capable to be member of AA and advisory committee. Any officer of any rank, right? So this is what will happen when a non-medico will become will try to give respiratory to a person. See what they are doing. So what is lawmakers with that? Any officer of any rank is capable to be member of the approved authority and advisory committee. Doctor's view: only officers of the medical department should be appointed on this post, as they only can understand the intricacies of the medical science. So we suggest that change in 7. When appointed for any part of the state or the union territory of rank below the level of joint director of health, family welfare, he should be, at least the person should be joint director of health and family welfare, so that he can understand the things. Provision 21, the advisory committee shall consist of 3 medical experts from amongst gynecologist, okay, obstetrician, pediatrician and medical geneticist. Now the expert committee, advisory committee is for the sonologist, and there is no sonologist in this. There is a gynecologist, there is obstetrician, there is pediatrician, there is medical geneticist. Only some obstetrician gynecologists do the sonology. So what is lawmakers' view? Experts in above committee are sufficient and competent enough to carry out the functions of advisory committee. So what we want to say that a pediatrician, a genetist in these committees cannot provide any input related to implementation of the act, which will better be done by radiologist or sonologist. So we want to change in 9. The 3 medical experts from amongst gynecologist, obstetricians, radiologist and sonologist. Provision 22. Every genetic center or counseling center or ultrasound clinic shall send a complete report in respect of all preconception or pregnancy related procedures or techniques or tests conducted by them in respect of each month by the 5th day of the following month to the concerned AA. This is what they say, to check the whether the center is following provisions of the act or not, or to take the action against the lawmakers argue that when other doctors can keep the record so meticulous, why can't you? I read it. The lawmakers argue that when other doctors can keep record so meticulous, why can't you? Now watch this. He is doing the thing so meticulously. Now there is a difference in the record keeping in other acts and this act. There is too much difference. This thing should be understood by the. So what will doctors do? Tired of intimidations for keeping proper records. This is how some people keep the record. Is it acceptable? No. So doctors use that in some states there is a mandatory online submission of F forms by the internet, and there is a need to avoid duplication as well as wastage of the manpower and paper. Record is useful when freshly examined. Tracing the patient shall be made easier, since with the passage of time, patients may shift their home. Some patients may even go back to other state, which will make it impossible to find any use of such records. So we suggest that add in 25, provided that if the record has been submitted electronically, no such report needs to be sent physically. Add a new sub-rule after 29, that is 9.9, that the records submitted by the USG clinic shall be audited by the concerned AA, and if any deficiency, inaccuracy or significant nature is found, the concerned AA shall inform such ultrasound clinic within the 3 months of submission and ask such clinics to furnish the required details. Otherwise, the record submitted by the clinic shall be deemed to be complete. For how many days you will keep the sword hanging on us? 23, provision 23. Genetic clinics means a clinic, institute, hospital, nursery, etc., which is used for conducting prenatal diagnostic procedures. For the purpose of this clause, genetic clinic includes a vehicle where ultrasonography machine and imaging machine or scanner or other equipment capable of determining sex of the fetus, which has the potential for detection of the sex during pregnancy or selection of sex before the conception is used. So we have problem with vehicle. Lawmakers say that every place where sex determination can be done is covered, including vehicle, because when there is equipment available, sex determination can be done at any place. Doctors say that only OBGYN sonography is capable of detecting sex of the fetus. USG is potentially useful technology for diagnosing and monitoring so many other diseases. Bringing every sonography under purview of this act has seriously jeopardized chances of curing patients suffering from other diseases. Hence, the place where no OBGYN sonography is done should be defined as ultrasound clinic and should be put out of purview of this act. Similarly, when a USG machine is transported from one place to another, for example, for repairing or a change of place, with a prior intimation to AA, should not be called as genetic clinic. So we suggest that add to explanation 1, a vehicle used merely to transport such equipment with a prior intimation to AA is excluded. Add to explanation 2, ultrasound clinic defined in section 2S, that is new addition, shall not come under this act except for registration and general supervision. Add a new section in 5S, the ultrasound clinic is a place where USG is used for any of the medical indications other than the indications requiring selection of sex before or after conceptus and not used as or for prenatal diagnostic techniques. Now section provision 24, we are 28, only 5 remaining. Section 32(2) I. 1. The minimum qualifications for the persons employed at a registered clinical genetic council or genetic clinic under clause 2 of the section 3. Lawmakers view is that only qualified persons shall be employed. Doctors view that qualification of medical professionals is the prerogative of MCI and now NMC. So the government should not tell what qualification required for which things. That is the purview of the MCI or NMC. So we suggest that you delete this amendment. This is not your area. Same 32.2. Code of conduct to be observed by the persons working at such centers to be laid down by the Central Supervisory Board under clause 4. Again the same, that code of conduct for a medical professional is the prerogative of National Medical Council now, and hence therefore we want to delete this 20. Now provision 26. A sonologist or imaging specialist or a registered medical practitioner having PG degree or diploma or 6-month training duly imparted in the manner prescribed in the rules. What they say that only qualified persons shall be employed. What we say that these medical practitioners were perfectly qualified as per the Act, and they cannot be singled out for passing a competency-based exam. New norms of qualification should be applicable for new people only and should not be applied retrospectively. This is applicable for all the laws. So we suggest to add to 21 that provided that those medical practitioners who were qualified to conduct USG as per old rules prior to 9th January 2014 shall continue to remain qualified under this Act. Now there is a conflict of interest here. Some radiologists suppose, some sonologists and radiologists suppose this move that those who are taken 6-month training, though it was MC recognized, they should not be allowed to do SG. Now we give away when other pathy councils allow them to do SG. Ayush councils are allowing them to do USG now and interpret the report. We give at that time, but fight within ourselves as to who should have the right to do USG within LFS. Now see this video. The cat is having a food. That is an allopathic doctor is having a food, and the rat is coming there. Now the rat is independentating the allopath, and he is eating the cat's food. What should cat do? The cat ran away. This is the reality of allopathy practice today. And the other people, that is the authorities, the governments, and other councils, they enjoy when we fight with our own brothers for who should do the sonography. In the coming days, sonography will be just like stethoscope, available to everybody, and we feel that sonography should be available to everybody because it is a so nice equipment. They enjoy when we fight in our brothers. Even they don't try to stop fight, but video shoot and circulate to other authorities to enjoy and extract the benefit out of our fight. See the fight between our brethren. So this is the things going on. Provision 27. The existing registered medical practitioner who are conducting procedures on the basis of 1 year experience or 6-month training are exempted from undertaking the said training provided they are able to qualify the competency-based assessment specified in Schedule 2, and in case of failure to clear the said competency-based exam, they shall be required to undertake the complete 6 months training as provided rules. Everyone knows this. So again, their view is that only qualified persons shall be employed, and our view is that the doctors use that no new norms should not be implemented. New norms should not be implemented retrospectively. Whatever you want to say, do is prospectively. So therefore, delete this rule 6.2 in 31. Now the last provision. Change criteria to be made prospective. These rules shall come into force with immediate effect in case of new registration. However, all registered medical practitioners employed in the centers on the basis of 1 year experience or 6 months training and failed to qualify the competency-based exam as specified in Schedule 2 shall have to apply and clear again 6 months training on or before the 1st January 2017. So again the same, we want that new norms should not be implemented retrospectively. Therefore, delete this rule 9 in 32. So we are coming at the end. The W.E. Deming said that a bad system will beat a good person every time. Therefore, when injustice becomes law, rebellion becomes duty. We can think positively also after seeing all these 28. सितम पर सितम कर रहे हो मुझ पर सितम कर रहे हो मुझ पर 28 तो हो गए ऊपर, वो मुझे शायद अपना समझने लगे हैं। या गवर्नमेंट हमें अपना समझने लगी है, सितम पे सितम करते जा रही है। So these are the references, inputs from so many sonologists to me, and IMA headquarters during project we did, and these are all other references from where I took all the things I told to you. This is the journey of self-regulation. Together we can, not only doctors, but lawyers, managers, and reporters, and government and police should also walk on this journey. Thank you. Thank you very much.
Thank you, Dr. Dinesh, for a detailed presentation on PCPNDT Act, telling in detail about each and every sections. And the best part was what the suggestions are, because ultimately sometimes theoretical and practical becomes very difficult when the politicians and the lawmakers, when they create law, they don't see the so they sometimes don't see the practicality. And now I think so with so much suggestions, if the government accept, we will see that how these suggestions get accepted, because then it will become more doctor friendly also. And already so many videos have shown that if it is not done, it will be damaging more and more the doctors. There are some sections which has to be deleted, some with amended. I think so a lot of people would be having questions, but because we are short of time, at the end we will take. So we will directly go to the next talk, and congratulations once again for a detailed presentation, Dr. Dinesh Thakre sir. Now we will go to the second presentation, which is again a very important topic. Now normally the court always relies. Yeah, Dr. Uttre sir, you want to say something?
I'll just add, just with your permission, I will add
100%,
what Dinesh said, because that is referring to the council. As Dinesh has said that he had pointed out that in the PCPNDT Act, it is written that as soon as charge sheets are filed against you, they have to report it to the council, and the council is supposed to suspend them till till the judgment comes into place. Now that was the case in the past. There has been changes in that, because we didn't go to court, but we made someone go to court and ask for a interpretation from the High Court, and we have got two judgments which are by two judges, which says number one that it is the right of the council to decide what the punishment should be as per the MMC Act. And the MMC Act, says that there is graded punishment, right from, giving a warning to, of course, suspension. And since that has come in, let me tell you, unless, of course, there is gross violation and, they have been actually caught in doing such selection, not even one case we have suspended for the last almost 5 to 6 years or 7 years, I can tell you that. So the powers of suspension lies with the authority which gives you the license. And that authority now, even in the latest judgment, it has come in the High Court also, where even the High Court does not have this power. The power is with the MMC. And let me tell you that we have taken adequate precautions, because we knew that you cannot suspend someone's license just for some, mistake like not wearing an apron or not putting up a board or something like that. Administrative problem which was there. And we have been doing that. So I think that was just an addition to what Dinesh has said, because people should not go with the wrong that the council immediately suspends you as soon as charge sheet is filed. That is not the case as of now, what is happening in the council. So I just wanted to put that one point forward. There are a lot of other things also I would like to comment, but I think, as you said, paucity of time, we will, if time permits, we will do it afterwards. Thank you.
Thank you, sir. Thank you for telling that Maharashtra Medical Council not only gives registration, but in worst condition can suspend, but they are also for the members, because see, always members look towards the council as a fatherly figure who also support them. You take Bar Council, you take CS Association. So I am very happy that Maharashtra Medical Council is taking proactive and also trying to protect and not unnecessarily suspend from these smaller issues on technical grounds. Thank you, sir. At the end, we will go in detail. Let us other topics we can get in discuss, because we have 3 and 4 more topics. At the end, we will definitely take in the Q&A section and try to solve the other issues. So the next topic, as I told you, it's again a very important topic. A lot of time the court sees towards the expert committee. The court says that we are from judiciary, we don't understand the medical words, the medical lines, the medical line of treatment. So they also tell the police people that before deciding or taking or filing a complaint, you always have to go towards, as the Jacob Matthew judgment also, that you have to take a help of an expert committee. Now, a lot of time people have in mind that how these expert committees formed, how they give this opinion, whether they are always very harsh, whether they keep it consideration the facilities available, because there are some hospitals which are in a remote place where there are paucity of services. There are some hospitals which are in the proper urban area. Sometimes the issues are related to corporate, which have all facilities, including an emergency sonography and MRI at the night time compared to a small nursing homes. So that's the reason. Who else? The best speaker I thought is Dr. Shailesh C. Mohite, and that's the reason I had invited, and he has accepted over a very fast to come and give the topic. I would introduce him, Dr. Shailesh C. Mohite. Dr. Shailesh C. Mohite is professor and head forensic department in TNMC, the Topiwala Nair Medical College and Nair Hospital. Coincidentally, I did my PG from Nair Hospital. I know some from that time, and we used to discuss a lot of time issues and cases medico-legally that time 1998-99. So thanks sir for guiding me that time also and motivating me. He is MD, DFM, DNB, postgraduate diploma in hospital administration and MBA. He is medical superintendent in Nair Hospital, member of Senate MUHS, Maharashtra Health Services, member of Board of Studies MUHS, member of the Quality Assurance Committee of Mumbai District for maternal deaths. Again, a very important, because a lot of times this maternal mortality meeting, when they happen, the gynecologists from different places are called, who all are connected to that, and the whole thing depends upon the, again, the expert committee opinion or the maternal mortality committee. He is faculty of Maharashtra Judicial Academy also since 2008. At present, he is also a president of Medico Legal Association of Maharashtra. So over to Dr. Shailesh Mohite, sir. So you can share your presentation.
Yes, thank you, Ashok.
Thank you.
Good afternoon, everyone. At the outset, I thank the organizers for giving me an opportunity to present this topic. A few brief discussions. What is medical negligence? So it is absence of reasonable care and skill or willful negligence of a medical practitioner in the treatment of the patient, which causes bodily injury or death of the patient. There could be an act of commission or an act of omission. Act of commission meaning committing something which a reasonable person would not do, and act of omission is omitting something or not doing something which should ideally have been done, like for example giving a test dose for a particular injection. These are various types of negligence. So medical negligence, basically civil or criminal negligence. Patient's negligence, as some textbooks say, where the patient himself is totally negligent. Contributory negligence, where it is concurrent negligence on part of both the doctor as well as the patient. Composite negligence, where two or more doctors are involved in treatment of the patient. And corporate negligence, which is related to machines and other instrumentations, etc. Let us begin with Jacob Matthew case, which says that in a private complaint against a doctor, it will not be entertained unless and until the complainant has produced prima facie evidence before the court in the form of credible opinion given by another doctor to support the charge of rashness or negligence. Previously, where doctors used to be directly arrested, now it is the investigating officer, before proceeding against any doctor accusing him of rash or negligent act, should obtain an independent medical opinion, preferably from a doctor in government service. So with this, the magnitude of problem is huge, though no actual updated data on the exact number of pending cases of medical negligence. The government of Maharashtra thought that since the number of cases of medical negligence was rising, an independent opinion was required. It was not possible for a poor man of the country to get an independent opinion. So Maharashtra government issued an GR. Okay. So there are two GRs, one is 2005 and another is 2010. I'm just sharing with you the copy of the GR. The second page of the copy says, ज्या जिल्ह्यांमध्ये शासकीय वैद्यकीय महाविद्यालय व रुग्णालय आहेत त्या जिल्ह्यांमध्ये खालील डॉक्टरांची समिती गठीत करण्यात यावी. So they have said that these are the people who would be there. वैद्यकीय अधीक्षक, that is medical superintendent of government medical college, he will be the president or chairman of the committee. There would be other three members, that is professor of forensic medicine, professor of medicine department, आणि ज्या विषयाचे प्रकरण संबंधित आहे त्या विषयातील प्राध्यापक or सदस्य, that is another member that should be there. Now some districts do not have a medical college, so there the civil surgeon becomes the chief, or at places like Nagpur where there are two medical colleges, IGMC and GMC Nagpur. So GMC Nagpur would see all cases of negligence in the urban setup, and those cases from the rural setup will go to IGMC or Indira Gandhi Medical College. This is how the GR was. DMER also has come out with a similar circular. Formation of the committee, who forms? So now in cases of negligence, if there is a charge, the investigating officer writes to the dean of the government medical college of that district or the civil surgeon. We have just seen the GR, 4 members. So committee is formed as per the GR to get advice in medical negligence cases and to get expert opinion in criminal negligence cases. Where? So it is a district level committee at government hospital. I've just discussed that where there are two medical colleges, there would be clear-cut distinction as to where the cases would go. If no government medical college, then the civil surgeon of the district will head the committee. These are the members. The circular or GR was in Marathi. I have translated over here. Committees deals only specifically with cases of criminal negligence. Civil negligence cases are dealt by MMC. However, some cases of criminal negligence can still be dealt by MMC. Kin of the deceased files complaint directly with MMC. If kin of deceased wants compensation, he may go to consumer court also. So what is the functioning of the committee? How it functions? So on receipt of a complaint against a doctor or a hospital, this letter will come from the investigating officer to the dean of that medical college. The dean will appoint a committee. President or chairman will receive the letter from the dean with all papers that have come to him with the requisition letter from the investigating officer. The president or chairman will call meeting of all members as per mutually decided date and time, which is at the earliest. Why at the earliest? Because there is a stipulated time frame in which the opinion has to be given. I will tell you about that. After it has come, the president or chairman will sit with the members, read all the case papers, see what are the charges framed, scrutinize all the papers, see whether all the papers are in proper place. Proper place in the sense they are properly paginated or no, all documents are there or no. After scrutiny of the papers, if any papers are inadequate, they are not paginated properly, additional statements are required, then the letter is sent for additional documents or statements. So the chairman of the committee will frame a letter to the investigating officer, and through the dean, it is submitted to the investigating officer stating that what are the deficiencies in the documents that have been provided to them. If need of recording of statements, explanation of relatives or doctor, has been requested by the committee, then IO or investigating officer is issued a letter to tell them to be present on a specified date, time and place with any other relevant document or proof. The meeting is then held on a specified date and recording of the statement of all concerned parties is done. Minutes are prepared at the time when the meeting is held. Cross verification of statements is done to examine all related documents. Discussion is held about the case among the members. They will draw a conclusion with a rationale. Even if no prima facie case is made out, the complainant should be informed about it, and his myths or doubt about the case need to be cleared. At many a times, it might be because of someone instigating him to file a complaint. So in that case, one has to try to explain him. So once his thoughts are cleared why there has been no negligence in this case, then the matter can be curbed over there. Once his doubts are cleared and after explaining that all possible things as per standard medical practice has been done. After all this has been done, drafting of final opinion, submission of the final report to the dean or civil surgeon is done. Final, who will submit it to the director or the investigating officer of the case within 15 days. That is specified in the circular of the director, which I have mentioned. Now coming to each point, one is cross verification of statements, first and foremost, meaning the complaint given at the time when they have filed a complaint with the police station, the police officer or investigating officer records the statements of the relatives. So this needs to be read out to him. First, find out whether he still sticks to his complaint, or in the meanwhile, he has spoken with other people and is satisfied with the treatment. Many times it might be because of excessive bill, etc., that there might be a complaint lodged. To examine all related documents, meaning date of admission, if any OPD records exist, those have to be seen. If there is a surgery, then whether consent has been properly taken, was it an informed consent, everything informed, or otherwise blood transfusion done or any other things, those whether have been noted and documented properly. In cases of negligence, like a mob is found inside that, or an equipment is
we can join that. And then we can start one. We can start one.
Or any foreign body found inside, when was it removed, in what condition it was, whether it is properly preserved, whether it is forwarded for histopathology to the forensic science laboratory. Are there any documentations on which these samples have been handed over, blood, all these documents? If the person is living, if he is dead, then the postmortem report needs to be scrutinized. What were the findings? Is the cause of death finalized, or is the cause of death still pending? One has to look into it. We have said that there are 4 members in the committee. Okay, but at times we might require people who are beyond that. If we see the committee, there is no one from anesthesia. But if we feel that there is an anesthetic complication or we require an opinion of an anesthetist, the committee can add more members to it and write down the specific reasons why they have invited additional members to that team. Note down their findings also. All the members are given copies or an opportunity to peruse all the papers. Draw a conclusion after all statements have been recorded, everyone has been heard about. Drafting of final opinion. How the opinion should be drafted. So the opinion should be a scientifically based one. It should be prepared, taken into consideration the circumstances of the case, example, place of occurrence, availability of resources, etc. Were there any extraordinary circumstances at that time? Were the roads blocked? Was there anything else? There was no blood in the blood bank nearby anywhere. What efforts have been made? All these documentations will be important. Statement of both the parties should be considered. What should we state? Whether should we state that there is negligence or no negligence? So the practice is, we write whether standard practices are followed. Was there application of reasonable care and skill on the part of the doctor? Is the practice a standard one? If no, was there any deviation from the standard practice? If yes, what was the deviation? Was it necessary for deviation? If any act has occurred which resulted in injury to the patient, was it noticed? If it was noticed, whether it was noticed immediately or after some time? Were any corrective measures initiated immediately? Was the error communicated to the patient or his relatives? Is the error documented? Were adequate steps taken to correct the error? Because of this error, was there any financial burden on the patient? Was the stay prolonged? Other things. Opinion should not mention there is negligence, no negligence, or gross negligence. Okay? Because we have been told to find out, was there any deviation from practice? So does it amount to negligence or otherwise? So we usually refrain from giving that there is negligence or no negligence. We just write that there is a standard practice and there was some deviation, or whatever deviation, or what are the things the doctor should have done and he has missed out. This is how we would write. Validity of the report on the basis of the final opinion of the committee. The investigating officer decides to register the case under 30A of the IPC or any other relevant sections. What do I mean by any other relevant sections? Meaning certain documents are not been made or have been purposefully destroyed or misplaced. So other sections like destruction of evidence comes into play. Samples have not been preserved. It might be out of ignorance also, but those sections will apply. Report submitted by the committee will be valid in the court of law only when it is testified under oath. Meaning, if the case comes to court, then the opposing counsel can call the committee members and cross-examine also. Now this report which has been submitted or record which has been prepared, the copy of the committee report should be in duplicate. One copy should be handed over to the authority who has asked us to conduct the inquiry. We obtain the acknowledgement of the authority. One copy should be preserved with the president or chairman for further perusal. Each member also can keep one copy for their reference in future. If they are called to court, it should be readily available. Appearance in court, the members may be summoned in the court for giving testimony in relation to the opinion given by the committee as to why did they feel that there is a deviation from the standard practice. I come to negligence related to maternal deaths. So every district has a quality assurance committee for reviewing maternal mortality cases. Such meetings are monthly meetings which are held. I am from Mumbai, and we have a Mumbai District Quality Assurance Committee. The members are Executive Health Officer, Deputy Executive Health Officer. At other places, district level, it is the civil surgeon. At Mumbai, we have a special family welfare officer. We have professors of OBGY, medicine, anesthesia, surgery, forensic medicine, pathology, matron, one representative from IMA, and one representative from Foxy. This is a whole team which sits together and reviews all maternal deaths. At times, from the investigating officer, in cases of alleged negligence, cases are forwarded to this committee for opinion. Because over the years, the investigating officers of the city have realized that, or at times it has come to us from the government hospitals, because here the number of members are much more. All specialties are involved in this. Rather, professors of each specialty is over here and gives their opinion, right from living cases to the post-mortem report. Every paper is thoroughly scrutinized. We have got adequate representations from others. We have a matron to find out whether proper nursing care was given or otherwise. The cases of negligence in maternal deaths, we discuss, review, interview the concerned doctors. The whole team of doctors is called. Discussions are held with them. If need arises, the relatives of the deceased are also called, and their statements are also recorded by us. Okay, so if they have any doubts of why a charge of negligence has come, even the casualty medical officer is called, who has prepared the first paper. At times, cases are referred to Mumbai from Thane and neighboring districts. So all the case papers, right from the first ANC registration, are traced. If the lady has gone to 2 or 3 private hospitals, all those concerned doctors are called, their statements are recorded, and we try to find out what type of delay was there in the treatment, primary, secondary, or tertiary, meaning whether there were services at that place or no. Was there a delay by the lady in seeking treatment? Was there any delay in transferring from a secondary level to a tertiary level? Was there an error of judgment or treatment at the tertiary level? These are the things which are looked for, and statements of others are recorded. There are about 7,700 cases pending. This is as per the Hindu. Problems and issues, sometimes police provide only a letter to look into the matter. So we cannot look into it, and at times matters might get delayed or documents might be submitted or late. Therefore, all this documentation for the committee becomes very important, because the GR says that you submit the report in 15 days. But every time we make a noting that the officer has submitted all the things or otherwise, and we start our 15 days from the date when all documents are received by us. Loopholes, there are no provisions for cases of alleged negligence in the same hospital from where the committee is formed. No provision for cases of alleged negligence if the committee member or one of the doctor from his department is involved in alleged negligence. Okay, so, or from that government hospital, then what is to be done? Thank you very much. Now I am open for questions.
Thank you, sir, for an excellent. I think so. We should spend at least 5 minutes for the question answers. Dr. Utturi sir is there, Dr. Thakre sir, and from Q&A box also we'll take Dr. Navarange sir also. So that it's a good opportunity, because we have Dr. Shailesh Moite, who is, and they supervise all those committees, and there would be, sir, Dr. Thakre, Dr. Utturi sir, you want to ask anything, or we'll take the Q&A box?
Sir, I have one question, 2 questions.
Yeah, Navarange sir.
Because we are facing it almost every month or so, some problem arising out of these committees and the reports. why not to give the opinion frankly, whether it amounts to the whatever papers are submitted to you, whether it is amounted to negligence or not. I would go a step further that you should actually opine that it is a gross negligence or not. Because, sir, the moment you write anything, even if it is positive for the doctor, police have interpreted in Pune that it is a case of negligence. So whatever you write below, they don't understand whether it amounts to negligence or not in legal parlor. So I would say that the moment you write anything, it results in the arrest of the doctor. So I would request humbly that you should mention whether it is a negligence or not, and that too if it is criminal, amounted to criminal negligence or not. I know this is not a final opinion. Ultimately, it will be decided by the courts. But then you write any explanation that this is a little deviation, this is a little deficiency. In one case, sir, I will just quote, 6 doctors went into the jail. I mean, they went under the arrest only because the doctor had tried to give maximum support to the patient life saving. 72 injections were given. And in that, this was mentioned in Sassoon Hospital report. This was taken as unnecessary injections by police and the case went ahead. So we had to intervene over there to explain. So even if it is, they had mentioned that everything was done as per the normal procedure, but 72 injections, they caught on that, and 6 doctors were sent to police custody. They were, till the time we intervened for 3 days, they were in the police custody. So I would humbly request you should mention whether it, because they are asking you this, whether this is amounted to medical negligence or not. I would say you go ahead and say it is a criminal negligence or not. This is my request. Because that's what police are asking, sir.
Yes.
This information from you.
As per the definition, what we said, is there any reasonable care, skill applied or otherwise, and is there a standard practice? So if we have written that there is standard practice,
They don't understand, sir. They
no,
don't
we
understand that.
explain. We see it is not only a postal thing that we hand over. While handing over, we tell them everything detailed. That's the reason we call both the parties and explain to them.
So do you call the doctors also? For
Yes, certainly, sir. That's the reason I gave you an example of our maternal mortality death review
No,
committee.
that is different, sir. I'm saying non-maternal mortality.
No, yes. All cases, we need to call the doctor and understand his side also. Many times,
Sir, at least in Pune, I can vouch, sir. Committee is of the opinion that we are not courts and we will not be asking for anybody's testimony. We will go only by the submitted papers.
But sometimes the paper are so
I know, sir.
not readable at all.
The
handwriting is not legible. So if the handwriting is not legible, how does one draw an inference from it? Or that's the reason I said, if the doctor comes, because see, when without reading properly, if I write negligence or no negligence, that would not be appropriate on the part of the committee. Therefore, it is very essential as to in what circumstances the doctor has done a particular thing. For example, if he has tried everything and all the blood banks are dry in the nearby area, then it is, he only would say. Many a times our doctors lack in all these documentations that we see, especially the date and time. Many a time, not only in private practice, sir, even in our government municipal hospitals, we will see to it that records are not proper. Therefore, we need to give an opportunity to our doctors to explain their side also. So if they have not said anything that time, we might record it at our given time as to what it is.
I entirely agree with you, sir. It is a very, very human approach, but this is what is not being followed all across. And that is our request. We had met the dean also, but they say that to call the doctors is not in our hands. It is only the papers which will go through, whether we understand the language or not. I mean, I think this is a majority experience.
Sir,
we will just suggest that this is being followed in Mumbai.
Sir, as per the GR, there is no clear-cut directions as to what all things it should do or the committee should do. So the committee can go out of the way also and make efforts to see that justice is given properly and nothing is missed out. Because ultimately this is going to help the court also. When they read the papers, they come to know how thoroughly. Therefore, we have gone beyond that, and though they have said only 4 people, but if it is a case of bypass and CVTS member is not there, how do these 4 members draw a conclusion? So we need, or a urologist is involved, we need to get those experts. At times, I would go beyond and say that at places, say in a district hospital where there is no medical college, even a private practitioner can be taken by the civil surgeon. Secondly is about calling the doctors. What I said is we as a committee give a letter to the investigating officer as to why the doctor's presence and statement is essential. One, because the notes, there might be certain abbreviations which the doctor himself is aware, whereas the committee will not be able to interpret.
Exactly.
Or something written which is not legible. So all these purposes, we mentioned the purposes why the doctor is required or so on, so page. Or if doctor is not willing, at least the doctor tomorrow will not be able to say that I was not given an opportunity to present my case. And we as doctors should know that no doctor is going to purposefully do some negligent act. If ever anything has happened, let us see what it is. At least it can be discussed out.
Thank you, sir. I will take this cue and meet the dean in next week. Thank you.
Yes, sir. In fact, we all should take a cue and probably write to the government to modify the GR.
Sir, what are your suggestions, Dr. Mohite sir? As you told, we should write, because now at present we have IMA, all national and state leaders also. Dr. Uttari sir is also there from Maharashtra Medical Council. If you feel the existing GR
Yes.
needs some modification changes which would be giving more transparency, can you give some suggestions so that we as an association can take it over to the government? And
Association can move it. Okay.
Certainly, Ashok, just as we said about maternal mortality deaths, where there is one representative of IMA and one of FOXI, almost all subjects have their association. So we can at least make a representation so to which principal faculty that case belongs, whether to urology, surgery, or one member from that association, the association can depute. So he will be again able to give us expert opinion related to these cases. Just
as you told
maternal
me,
mortality, we have head of gynecology. But
Right.
apart from that, these two members are there.
So as you told in the beginning, there are 4 members which are there in the
Yes.
committee. So a lot of times, do you feel all 4 members have a consensus opinion, or sometimes you feel two might have different opinion? Then how you go ahead, because it's a even number.
Yes. See, now most of the cases are usually of surgical opinion.
Okay.
Okay. And if you see that in this, we have one from forensic, one from medicine, and there would be one surgeon. Many a times we come to a consensus because it is a subject expert who would say, and the forensic expert, whether what has been done in the surgery or what is there and what are the postmortem findings, do they match or otherwise?
Yeah, Dr. Uttari sir.
Yeah, I think I must congratulate the organizers and of course my very, very close friend, Dr. Mohite.
Sir, thank you very much.
He has put up all the details in such simple terms, because we always find that, when we get the reports from the medical colleges or from the CS, that many a times we find that there are some problems over there which we are finding even in the council. So my only request would be, as we have been successful from the council to insist, and the government has now accepted, that whenever the CS hears any cases, there will be one person who may be a MMC member or a representative of MMC who will be sitting on that committee whenever the cases are held. And this has already started everywhere all over Maharashtra. This is what we have been successful in doing in the last 6 months. Now the same thing we are trying to push even through DMER, that even when the medical colleges are hearing these cases, there should be someone, just like how Dr. Mohite said, that there should be someone from the organizations once it comes into the hand of the MMC. Either the MMC members who are supposed to be experts in medical legal cases, or we may be choosing someone from the organizations to which faculty that problem relates to. Now, my only one contention over here is that many a times, like how Dr. Navrange said, that the practical aspect is that, the whole opinion is given only on the papers which are submitted to the committee. And sometimes I would again say to all my members also, that is the importance of documentation, very, very important. If you have not documented in details how you have treated the patient, nobody is going to know that if you have treated him properly or not. And then we cannot blame the committee also for giving their opinion just on what is written on the paper, because you have written it on the paper. So my request would be, and I'm trying to get it through to the government also, that just like, because this is a criminal case and tomorrow the doctor will be hauled up, will be arrested. So my request to the government, and we are trying to get it through, is that just like how in the council we call for expert opinions, I think the committee should also be calling some expert opinion, not be in details, but there should be some expert opinion which can be called by the committee, and especially call the doctors and the complainants, both of them, so that natural justice is there. And many a times the doctor is not, arrested for not proper paperwork that he has done. So that is the only thing I think, if Dr. Mohite can help us out in that also, so we can push that through to the government and the medical education department.
Yeah, sir. Dr. Mohite, sir.
Thank you, sir, for your suggestions. And I'm very happy with you at the helm of affairs. You have already begun. That MMC member is there. Okay, so this is a very good big thing, and happy to note that. I will definitely add in my presentation for future. Sir, I think two things should be done. One, we need to train our faculty or doctors that before submitting any documents to the police, please verify for yourself. You might not be in proper frame of mind. Call someone from the IMA medical legal cell or someone, let them independently scrutinize and see whether all the papers are in place, all documentations are there, whether your papers are paginated, your consents, etc., are in proper place or no. That one should be done. Second is, we can do video recording also of this whole process. That is what I feel. These are my two suggestions.
Thank you, sir. Dr. Mohite, sir, for that excellent suggestion. We will definitely, with Utture, sir, and IMA will try to take this, and so that it benefits our members. And the most important line you said is the mind framework. When that issue has happened, the doctor might not be in good framework, and that time submitting the paper sometime and leaving those important things which he would have done. And the court always says whatever is documented only has been done. So even if you would have done, not documented, later doesn't help, or it's seen with suspicion. I think so. Dr.
Medical college.
Rajesh Dere sir wanted to add something. He is professor and head from Sion Hospital. Dr. Rajesh Dere sir, you can add.
Yeah, good afternoon, all of you. I'm professor and head at Sion and dean at BKC now. I want to add, Dr. Navrange has raised a good question. The problem is the Jacob Matthews case. After that, there are few other verdicts in medical negligence also, which is not taken into account by many medical fraternities. It clearly says the committee has to opine about that it is a gross negligence.
Yes.
But even after, I've gone through many reports of any medical college, the so-called committee formed by government of Maharashtra, which mandates that it is only the government college who can give the opinion, which does not, is not consistent with the Jacob Matthews case. Also, you read that carefully. It doesn't say from government medical colleges. It is from a panel of experts in which one of the jury has to be a person from that subject. Now, even after the opinion is not clear-cut, whether the allegation against the negligence of that doctor, practicing doctor, is gross, even after that the police is filing 304 sections and unnecessarily arresting and sending that doctor to jail. So, first of all, the committee has to read properly the Jacob Matthews judgment, or there are 3 more judgments in negligence of medical practice after that till now, that the committee, the competent committee of experts, should clearly opine that the act alleged by the complainant amounts to gross negligence. Then only section of IPC 304 B can be applied, 304 can be applied, and the doctors can be arrested. But randomly, even though our committee members are writing ambiguous opinion that there was some fault, I feel there was some negligence, and minor mistakes in documentation, just like date and so on and so forth. If we carefully read all the judgments, even you take Jacob Matthews and thereafter judgment, that doesn't amount to gross negligence. So this is my submissions. So the Jacob Matthews case is not properly interpreted and understand by police officer as well as the committee members at large.
Okay. Yeah, Dr. Shivakumar, sir.
Yeah. In one of the cases, the expert committee opined that if there was a negligence on the part of the doctors, and the police people, they took it as a gross negligence, and that they were arrested under 304 years. There are many instances are there. But whenever there is negligence, you must write whether it is a gross negligence or a simple negligence. So accordingly, the police can. But invariably, police people, if you mention it is the inadequacy of the treatment or some deficiency of the medical service or some negligence, they interpret as a gross negligence only, the book under 304. That's what we have seen in many cases.
But in one dental case,
really
in one dental case,
yeah,
that consent does not seem to have been signed. Now, on this basis, the doctor was arrested.
Yeah.
So it did not happen.
No.
That is our submission.
Sir, I made it clear.
Amounts to indecent assault.
You can talk.
Examining or operating without consent.
Yeah, Mohit, sir. All yours.
Hello.
Yeah.
But without valid consent, how can one operate? If the doctor in his statement gives any specific reason why he has not obtained consent because it was an emergency and there was no one else to give consent at that time, and under 92 of the IPC he has gone ahead and operated under good faith, then it is a different story. Otherwise, if he is competent to give a consent and it is not obtained.
Good afternoon, sir. To Mohite, sir.
Yes, sir.
If a patient dies during treatment and post-mortem examination is done, the papers are handed over to the investigating officer, police, who afterwards foul play with the practitioner or tries to blackmail him, instigate the relatives. So why not the PM findings with the sealed envelope directed to the civil surgeon or the concerned department in medical college?
No, post-mortem report has to be given only to the investigating officer and not to the civil surgeon. Civil surgeon can keep a copy or he can forward it. If you see the last page, it is mentioned over there, copy forwarded to civil surgeon.
So the investigating officer or police, he blackmails the practitioner or he communicates with the patient's relatives that something is wrong.
But that is, the relative can always complain, because in that PM report, nowhere does any doctor write there is negligence or otherwise.
Right.
The cause of death never mentioned that there is negligence, sir.
Right. Point taken, sir, because the cause of death only tells the cause of death. Ultimately, the committee has to decide. And if the doctor feels anytime there might be something against him, he can go and take anticipative bail, or he can challenge the committee report even in the court of law where the judge are in the better position. They can interpret, and the difference of opinion can happen.
Yes.
So there is nothing to get feeling sad that the committee has given a report against him. Yeah, it gives a psychological benefit to the patient who has alleged, because already committee has given that some amount of negligence is there. But always it is challengeable. People should not lose faith that once the committee has given, we have now exhausted all the options. They have still options, and they should go ahead and use their lawyer and fight the court case and try to justify that what they did was right.
Yeah, Dr. Mohite, the investigating officer, even after getting the expert committee opinion, okay, can you rely upon that, or else he can take one more second opinion?
There is no provision for one more second opinion.
Yeah.
If he goes for second opinion, he cannot go to some other district, because you have to take from the district only. That is the GR which says. And if he feels so, then he might approach the director stating that these are his reasons for not believing the committee.
Yeah.
For example, if the postmortem report says that the sutures had given away and there was hemoperitoneum, which the committee has not considered, and the postmortem report clearly states, and the committee has said that there is no negligence. And if he feels that this is a gross error, then he might go to the director and ask for specific permission to go to another state.
No, can they? Can the patient relate to
medical
give in writing? Can the patient give in writing to the IO stating that we do not trust this committee report? You please take some other institutional opinion. That time, what do the university officer will do?
There is no such provision for the relatives.
Can I please? Can I?
You can go to the High Court
Can
if
I
they feel so.
Can I
Yes,
please?
Dr. Dere, bola.
Now, in this, sir, what now the sir has said, he, along with going to the higher agencies in medical field, the CRPC allows the investigating officer to put up such matter if they do not have faith in the opinion provided by the expert to class 1 judicial magistrate of that area, and appropriate order can be sought for further opinion from any competent committee as the honorable class 1 judicial magistrate feels. This is one of the reliefs in this which can be tried.
Sir, in two of the cases which I was involved to help the doctor, the parents did not believe, the patients did not believe in the report given by the local committee.
Yeah.
So with the help of the police officers, they got obtained another opinion from JJ Hospital. So this is a practically fairly common procedure. So they can raise the doubt and they can get it done.
Yeah.
Even without intervention of the court.
No, but in that case, there
It's
is
very uncommon.
As per the GR, there is no such provision.
No, there is
and
no regular provision.
Later on, whether it would stand in court, that is another thing, because as per which provisions has this been done.
But they do it, sir. Police take
They do
it
it.
on insistence of the insistence of the relatives.
He also said, yes, sir.
On insistence,
Naurangi, sir, yes.
saying that they are not satisfied with the report, they just agitate, and the police commissioner transfers the, asks for another opinion from another area. So in our case from Pune, the reports are asked for a second opinion from JJ Hospital.
I will just
cases I know of.
No, sir, this might have happened, but I will just find out whether under which provisions are there any specific provisions for this to happen, because again, if it is a district-wise committee that as per GR, on what basis, therefore I said, if it is the director who is the head of the state is involved, because then it is fine enough and with justifiable reasons if he also feels, yes, there has been injustice that has occurred, therefore it should go to another committee. Because if the another committee also gives the same report, how many times we will go to different districts till the relative is satisfied? In postmortems, we see many cases whereby if they are not satisfied with the autopsy, they go to the High Court and obtain an order to go to specific court. Because I know Dr. Dere has done many cases where High Court has referred to him matter where postmortem was done, first postmortem at JJ Hospital. So in that cases, High Court can give relief. We are aware about that, but in these cases of negligence, whether any judicial magistrate can interfere and direct, I am doubtful. I will update my knowledge and find out. I will probably communicate with Dr. Shukla. If I get any other material, I will be happy to share with all of you.
Right, sir, because it will be beneficial, and then because Dr. Jayant Navarange sir is helping our members in many cases. So it will be definitely helping our members. I think so. We have taken at the end, if we still have time, we will take some questions. Otherwise, we'll go to the next session. Thank you, Dr. Shailesh Mote sir, for not only giving an excellent talk, but also solving most of our queries. It was our really privilege to hear from you with so much busy schedule. But thanks once again. So we'll go to the next slide. So now we'll go to the third topic. Again, a very important topic because doctors play a double role. They not only are a consultant, they are also a lot of time hospital owners. Let it be a small clinic, they have their one or two staff working there, a polyclinic, again they have. So there is something which we want our members to know. Their liability is not only on them. It is, they also have something as a vicarious liability. It's nothing like it is my hospital, but the operating surgeon was different. So I have nothing to contribute from my side. If there is a negligence occur, only it is pure his. His headache is there to manage the oxygen, everything. So we have to understand, and today we have an excellent speaker on an excellent topic called vicarious liability and its implication with court judgments and practical. I would introduce Dr. Jayan Navrange sir. He is a pediatrician with LLB degree. He is a legally qualified doctor. He is executive trustee of IMA Pune, ex-president Indian Association Pediatrics Maharashtra State, chairman IMA MS SSS, that is Social Service Cell, and n number of gold medals he has got during his medical qualification. The other part he does is he remains fit. He doesn't look that old. I will not tell his age. He looks very young. He's a 28 half and full marathon runner and a trekker. And he has donated blood 65 times. Can you imagine? He is a real person who has worked for the members and the society. Donating 65 times till now is a huge achievement, sir. Works for Dinanath Mangeshkar and Sahyadri Hospital. From last many years, he's received a number of awards, specifically the Bertha Holt Award in USA. The main thing I would like to say is he is very close to members. Whenever a member is in need, he is a person who's always approached, irrespective of the date, time, and he's always there to help them whatever way he can. And that's the reason. And even at this age, he comes and attends all our conferences to guide us, also to see that how more and more better way we can help our members to get them out of these issues where, as in the beginning he told, a lot of time members do with good heart, but sometimes they have some small lacunae which sometimes is taken in the wrong sense against the doctors. Over to Dr. Jayan Navrange, sir.
Thank you so much, Dr. Shukla, for so lucid introduction. And my topic today is very interesting, that in spite of you not being having any blameworthy incidents, you get sometimes caught wrongly. So I will be talking about the vicarious liability. I'm just bringing my first slide. Yeah, I'm very much indebted to you for asking me to deliver speech on this small but important topic. And I also welcome all the 290 members who are attending, and especially Dr. Shukla, Dr. Thakre, and two Shivkumars, one from Mumbai, Shivkumar Uttare, and one Shivkumar from Dharwad. And so many, all my colleagues over here, Dr. Meenakshi is also there, Dr. Pute is also there. So I'll be brief because two very important topics have been covered, one by Dr. Thakre and one by Dr. Mohite, very adequately, very nicely covered. And these I have given definite insights to all of us and clues how to go ahead with problem solving rather than posing the problems. I will discuss about the vicarious liability principle. What does it mean? What are the illustrations? What necessary steps you can take so that you can safeguard yourself. And to begin with, what is the first case where this has been indirectly mentioned? It is the first case in India, I am saying in India. So what is the principle? I will tell you in the next slide. Why is that many people may not be knowing what is meant by vicarious liability. So why this principle has come? So the first Indian case in which it has been adequately elaborated is the every time there is a case of medical negligence, this particular case is quoted from various angles, and that is unfortunately from Pune. Dr. L.B. Joshi versus Dr. Trimbak Bapu Godbole case, way back decided in allegations were made in 1959, one doctor against the other, and the decision came in 1969. So 10 years was the period, because this Dr. L.B. Joshi lost the case at civil hospital, district civil court. He lost the case at the High Court. That time consumers were not there. And lastly, he lost the case in Supreme Court. And this is what is the fundamental judgment given about deciding what is meant by medical negligence. See, there in the law textbooks, there is nothing separate topic as medical negligence. There are topics of negligence in under tort as well as criminal, but there is no separate definition of medical negligence. So it goes by judge-made law. Now, what does this particular judgment has said? Number one, just before this, there is a preamble that the one who wants to treat is ready to give treatment, assures the other party that he possesses the necessary skill and necessary knowledge. So necessary knowledge means the approved university's degree in medicine. Skill means he is duly registered with the medical council. So I'm coming back to the basic principle of negligence, and then I will come to vicarious liability. Unless there is some negligence, there cannot be a liability. Now, in this case, it is further mentioned that doctor has 3 duties. Now, what are these 3 duties when he is treating a patient? Number 1, he has to decide if he will undertake this case for treatment or not. So it is adequately made clear that you can refuse the treatment to a particular patient. Of course, into bracket, except emergencies. So decide if he is, so here it mentions whether it is he is competent or whether he is willing to undertake the treatment of this case. You can refuse the patient saying that he is beyond my scope, or I am not well, or you can say that he has deceived me in the past, he has not paid my bills, etc., etc. He has behaved with me very bad. He can refuse the patient except in emergencies. So except in emergencies, it will be decided by the courts only, but it goes by common sense. Number 2, once you decide that I will undertake the case treatment of this patient, then you have to decide the line of treatment. See, it's a single sentence, decide the line of treatment. But this decide the line of treatment in allopathy means you have to take the history, do the examination, do the necessary investigations, come to a diagnosis, come to a working diagnosis, and then start treatment. So he has to decide what is the line of treatment. And third is the important point where I am going to dwell upon today in next 10 slides is thirdly, he has to decide how to implement the decided treatment. So you decide the treatment that you want to give treatment, say for example, in a case of acute abdomen, you want to do a laparotomy or you want to do a selective, elective, whatever way, appendicectomy. Then how to implement that? You just alone cannot treat. You require assistants, you require housemen, you require assistant doctor, nurses, ward boys, pharmacist, pathologist, anesthesiologist, everybody. So this is where to implement the decided treatment, methodology of implementing the treatment is an important duty cast upon the doctors by these 3 statements. Decide if he will undertake the treatment of this case. Number 2, decide the line of treatment after diagnosis. They are not mentioned this in the judgment. I am putting it here. And to implement the decided treatment. So any breach of any of these 3. So this sentence is important. Any breach in any of these 3 is equivalent to medical negligence. They are not mentioned criminal or civil. That will go by the level of negligence. But any breach of any of these 3 amounts to negligence. And this negligence is actionable in law. And that is what leads to damages, means compensation. So compensation or punishment, either of the 2. So please remember, I am concentrating on point number 3, the way you want to treat. For example, you are working in a clinic. You are dependent many times on your compounder. You are also dependent on some help from somebody who is trained by you, even to apply spirit for before giving injections, to immobilize the patient, child patient, to apply the splint. So many things are there. So for implementing the treatment, you need assistants, contractors, the staff, etc. And their wrong is your wrong. Who is employing these people? You are employing these people. You have chosen them. After due process of selection, you are chosen them. They are working with you for several years. So just as you benefit from employing them, you can suffer also. So this is in a nutshell that you are responsible for whatever your assistant is doing, whatever your nurse or your contractors, subcontractors, etc. are doing. I will elaborate upon these. Now, why this principle is there? This is based on the legal principle of what is called as master-servant relationship. That means you are dictating something to be done. Clean my room, paint my wall, etc. So same way you are telling your assistant that give this injection, write down this prescription, write down this discharge card, send a blood sample for grouping and cross-matching, whether it is labeled properly or not. Sometimes at least you have to keep a watch. So what is the principle is the respondent superior. Who is to respond to the call of allegation by the patient? It is the doctor in charge, the employer. So this is the principle, and this is applicable only on the civil side. That means only on the compensation side. It is not at all, please, I will be re-emphasizing later on, it is not applicable for the criminal side. It is only and only for the civil side. When the cases go to the civil court, or for us, usually the consumer court. So it is assumed, why this principle? It is assumed that the employer, that means you and me, who is employing, or if you are acting as an employee under some big corporate hospital, then you are an employee, your employer is the management. So it is assumed that the employer is responsible for the acts or omissions or inactions of his employees, as he has chosen that employee to get his work done through that person, through his agent, that is the employee. So ultimately, the civil responsibility is that of the principal. So principal here is employer. I made a mistake here. So the ultimate civil responsibility is that of the, it should be employer, not employee. I'm so sorry. So also, generally speaking, he is in a better financial position to settle the claim of the third party. So as far as hospital setup or clinic setup is concerned, he is not bothered. Patient is not bothered whom you are employed, who is your assistant, who is your compounder, who is your ward boy. They are not concerned about that. They want the things to be done, get it done through you. So they are holding you responsible. So similarly, for the patient, he is a point of single contact, but therefore he puts a case against the employer and not the employee. He knows the employer, not the employee. So from all these angles, this principle, vicarious liability, is the liability of your staff and subordinates and contractors whom you are employing in your setup, with whom you are working. The primary responsibility of settling the claim is on the employer. That means the main doctor. Please note that once again, this principle is applicable to the civil side and not at all in the criminal side, because the punishment, fine, etc. has to be suffered individually. So as far as criminal law is concerned, it is an individual law, whereas in civil side, the responsibility is of your all subordinate staff and employees. Many cases are there. It is not that the cases don't occur. There are many cases, or at least partly these cases are there, where the vicarious liability principle is coming into picture. Let's see the practical aspects with illustrations. And this is the classical hallmark example, which is underlying. Please be very attentive over here. There are two principles here. What is meant by vicarious liability? Whatever is done by agents, that means your staff is your agent, that is in legal language, subordinates, contractors. So for example, you are calling anesthetist or pathologist or radiologist on your behalf to your hospital for giving anesthesia or doing certain tests. He is your independent contractor. So even independent contractors for special services, they come as a liability on you. So employees which result, so it need not be that he is employed every time. It can be an independent contractor, which results in injury to the patient, becomes the liability of the doctor or the hospital. So in a small setup, it would be the doctor. In a bigger setup, it will be the management of the hospital. So there's the principle of respondent superior is there. The classical example, and I will just give a story in 3 minutes, that this is Harjot Singh Ahluwalia versus Spring Meadows Hospital. What happened in this case? This case belonged to 1994, and the decision from Supreme Court came in 2000. Because 1994, there was a dilemma whether consumer courts are covering the medical cases or not. So 1995, it became clear that consumer courts would entertain the medical cases also. So it went to the civil side. Now, what is this case? Harjot Singh Ahluwalia is a child who is now an adult, is still alive. In this case, he was being treated rightly after diagnosis with blood culture, a case of typhoid fever in New Delhi. The Spring Meadows Hospital is something like a 400-bedded 4-star or 5-star hospital. And here, the patient was getting treatment for last 4 to 5 days. And on a Sunday morning, everybody was sitting at home. And that time, Ramayana was very popular serial on the TV. So everybody was sitting at 9:30 in the morning. And anyway, the patient, it was a Sunday morning. So doctors were at home. Only the house staff was there and the nurses were there. The child was being given chloramphenicol because that time it was responsive to chloramphenicol. And chloromycetin was the drug which was prescribed. In private setup, you know very well, as soon as the medicine is over, the nurse would write down the medicine. They go to the store of the hospital, they read the medicine, and the nurse injects the medicine. In this particular case, the nurse was in a hurry to attend the church duties, and it was a change of duties also. So she wrote down, instead of chloromycetin, it was a mistake, she wrote down chloroquine. See, chloramphenicol was prescribed. Instead, she wrote chloroquine, and the chemist downstairs gave an ampule of Lariago 5 ml. What happened is that the nurse was in a great hurry. She just cut open the ampule and injected into the IV tubing, and there was an instant brain death. Patient went into cardiorespiratory arrest. Any amount of resuscitation and revival did not result in any saving of the brain. So it is a case of brain death, unfortunately. So what has happened? Whether the doctor was negligent? No. Whether the hospital was negligent? Partially, no. Whether this consultant who had written a prescription of chloramphenicol was at fault? No. That lady pediatrician was of this child then was 4 years old, was of the same seniority as my seniority, and she was sitting at home. Everybody rushed to the scene. Everybody was called. They survived the patient, but not an intact survival. So the case went to the courts, and Supreme Court has uttered this particular thing that this is a case of vicarious liability, that even if there is no direct staff which was employed by the hospital, and at that time this was the highest compensation given was 17.5 lakhs, because they calculated that this child would survive for years together, and it will be the cost to maintain this child with servants and all that. So this was an eye-opener that vicarious liability is the. Now I am giving you one more twist to this case. This hospital was smarter than average hospitals. So this is a lesson to us. We take indemnity insurance ourselves. We take the indemnity insurance of the hospital errors and omission policy also. There is a clause that you can have a cover of unqualified staff also, and all of us have unqualified staff in our hospitals and clinics. So you give 7.5% more premium, and the insurance company covers the unqualified staff also. What happened in this case, that 17.5 lakhs was given. I mean, this is apart from vicarious liability. 17.5 lakhs was sanctioned and passed by Supreme Court, and the insurance companies, as usual, they are eager to collect your premium, but last to settle your claim, they found out that this nurse was not a qualified nurse. She was A&M, so not qualified to give IV injection. However, this hospital, being smarter, had paid 7.5% extra premium to cover their unqualified staff. And when this was pointed out to the Supreme Court, because the insurance company said that we are not liable, so the hospital went again to the Supreme Court, saying that the insurance company is trying to avoid, when we have got the valid insurance, the Supreme Court gave the judgment in the next 5 minutes that the insurance company must pay. So this is how you should be covering yourself for unqualified staff also. Anyway, liability exists despite the absence of blameworthy conduct of the master. So legal principle again is respondent superior. It is only on the civil side. This is again and again I am emphasizing people. That is because people claim even for the criminal side. So vicarious liability, I already mentioned this particular case, and the second case, and then there are n number of cases. This is an important point, that even if the doctor is only a panel doctor in a hospital, hospital is vicarious. This is a very different point. Even if doctor is only a panel doctor, visiting doctor, hospital is vicariously liable, as bill and discharge cards are issued by the hospital. This was the judgment of National Commission 1997, and this has been repeatedly upheld by various courts, including the Supreme Court, which I will narrate in the next 1 or 2 slides. Now, another case possibility, and this happens too often in a private hospital, the employee doctor commits a civil negligence. During the course of his employment, the compensation is to be settled by the employer, as we saw, or the doctor, or the hospital, or the clinic, whosoever has employed that doctor. The employer can in turn, this is new, I mean, this is many people don't know. The employer can in turn recover the amount from the employee. But this is subsequently. First and foremost, you have to settle the claim of the patient. You can recover that amount from your employee who was at fault, once that particular fault has been accepted or proved in the court. So you can recover. Employer can recover from the employee doctor or take the disciplinary action. But to tell you frankly, this is theoretical. It is very difficult to do this in private setup, and almost impossible to do it if it is a low wage employee like a nurse, ward boy, assistants, etc. So it is not possible. This is only theoretical consideration, that you in turn can recover from your erring employee. This is just to keep a threat on them. A corporate hospital may never issue an experience or good behavior certificate, etc. to such an employee. So that much you can do. So this is one illustration in a private setup. However, what happens in a government setup? The liability is transferred to the employee, and who is the employee? So there is a hierarchy. Employer is the government through the ministry, through the secretary, through the dean, through the head of the department, professor, lecturer. I'm going other way around. So in short, any mistake done by your houseman, registrar, ultimate liability is of the government, state government, central government, local government. But here, once the guilt is proved, the government settles it first with the patient, but they can easily recover from the employee by suspending that employee, taking disciplinary action. They will suspend the salary, take it out from gratuity, pensions, and recovery, even if not completed, as if it is a recovery of the land revenue. So it is not that simple. Government can definitely take it from the employee. In short, it is a very difficult to recover in private setup, but not in government setup. So have adequate, now this is the point of importance, practical point, that have adequate insurance indemnity cover for yourself, which will cover the indemnity, I mean liability of your staff also, and also your indemnity policy of the hospital. So that will cover, and take it for 7.5% extra premium and cover the unqualified staff also. Now next point is very important. This is my last point. Even if the hospitals make an agreement or MOU from the visiting employee, doctors like us, that they alone will be responsible for the negligence, such documentation does not stand in law. That is number one. This would definitely bring smile to the practicing doctors. And their responsibility remains 100%, as is seen in very many judgments. I mean, there is no exception I've seen. Because the hospitals verify the competence of the specialist before employing, or before giving them the visiting status, or putting them on the panel, and they are allowing them to use the hospital facilities, and the hospital earns out of his services. So these are the sentences from Supreme Court, several judgments. Usual compensation is in the order of 60% by the hospital and 40% by the visiting doctor, usually. Even in Kunal Saha's case, which is the landmark judgment of 12 crores, Dr. Mukherjee, who was the number one accused, had to pay only 10 lakhs out of 12 crores. So this is the difference. So even if the hospital says that they have made an MOU while putting you on the panels list, that they will escape, even I have signed these agreements, but they do not stand the the test of courts. It is not important whether the doctors are resident, permanent, visiting, temporary or part-time. It is based on the logic that the act performed by the consultant is deemed to be the service provided by the hospital. So patients are coming to the hospital, and there is always a debate over sharing of liability between hospital, salaried consultant, a visiting consultant, hospital or institute. And there are many cases, as I told, there is one more case from West Bengal Commission that in municipal hospital versus Srimati Sukla Chakraborty, cholecystectomy, a swab was left. Doctor said it is because of the hospital nurses' negligence. It was held that it is always a joint responsibility. So doctor, surgeon operating is called a captain of the ship. So he is equally liable. One more landmark judgment. Many people have missed this judgment. Dr. Pradhan versus Leelavati Hospital, whereas in state Consumer Commission in Maharashtra, cataract, it got infected, loss of vision. Both consultants hospitals held liable. Now cataract led to infection. So consultant pleaded that asepsis is the sole responsibility of the hospital. This was turned down. So it is the both together liability that they had to compensate this doctor. Since this time, this particular judgment, it has resulted in a good thing that government of Maharashtra made separate operation theatres compulsory for every hospital if there is an eye surgery conducted in the general hospital. So this was the good outcome out of this. Even if the hospital takes indemnity from the panel doctor, it is still responsible. I would skip this case because it's not directly a case of vicarious liability. Now the point is, this is probably my last slide, what precautions an employed doctor should take. Employed doctor. I think this is a practical importance. Preserve the appointment letter and period of employment and duty hours. Carefully observe the service conditions. Use only the supplied stationery, stamps, place, machinery. You can go on their behalf to a agreed camp setup, but then you are going on behalf of the hospital. Have your individual indemnity insurance also. Don't just say that I am employed, I don't require anything. You should have your indemnity separately for very many reasons, which is beyond the scope of this talk. Report any deficiency or this is very, very important. Report any deficiency or non-availability of equipment or facility or expert. In Pune, in a very big setup, there was no pediatric ICU, and there was a case of dengue shock syndrome. The doctors were all the time saying that we cannot treat this case and we need to shift to. There was an adult ICU and the management insisted that you treat in the adult ICU. So when they came to me, I said that you quietly write, you go on treating, don't leave the patient, but insist for a transfer. And number two, give in writing that these facilities are required to treat this patient. That saved this particular pediatric consultant. Any notice received from patient or lawyer, ask the complainant to direct it to the management, stating that you are in employment. Also inform the management immediately. So with this, I think all of you, those who are employed, can take necessary precautions on those lines. Now this, I just want to end up with this, that Supreme Court recently, the same judgment which I mentioned in the past, that it is a joint responsibility, is reiterated again as latest as on 18th of December 2019 in a case of retinopathy of prematurity, in the case UU Lalit versus, sorry, these are justices, bench of justices UU Lalit and Indu Malhotra, and I will just utter these words. It is established that a hospital is vicariously liable for the acts of negligence committed by the doctors. This is very important. Engaged or empaneled. See, this is important. Engaged or empaneled to provide the medical care. It further said, it is common experience that when a patient goes to a hospital, he or she goes there on account of the reputation of the hospital and with the hope that due and proper care will be taken in the hospital authorities. If the hospital fails to discharge their duties through their doctors, being employed on jobs or employed on contract basis, it is the hospital which has to justify the acts of commission or omission. This is the landmark judgment, and the decision of the Indian courts in majority of cases is as what I mentioned. So I think I will end up, and these are additional references. Thank you very much for a patient listening, and I'll be happy to answer some of the questions. So this is a common question: hospital and doctor relationship and how the liability is shared. Thank you so much. Thank you, Dr. Shikwan.
Thank you, sir. Thank you for an excellent talk and a very important talk, because people a lot of time don't give them these topics very important, but when they are caught on the wrong side, then they suddenly realize they have to spend a huge amount, because whatever the liability of staff is in the court of law, ultimately it has to be spent from their pocket only, because they are not going to pay and the hospital would become liable. And people a lot of time take their own indemnity, but they don't take their hospital indemnity, specifically of the unqualified staff, which becomes more problematic. And we would request that you should take and cover your hospital also, take both policy, your own indemnity as a professional indemnity, but do not forget to take your hospital indemnity to cover all your staff, qualified and unqualified. So we can take some few questions before we go to the next topic. Anyone from the panel wants to add, or in the Q&A, if there is something specific to this talk, we can take, or then otherwise we can take at the end. So I think so we will go to the next, sir, and we will take at the end so that we can discuss, because a lot of things have to be asked. A lot of people who want to ask questions at the end. We will take all Q&A also, which are pending. So I think so we'll go to the next speaker. The next is Dr. Pinky Shah, madam. She's going to give a talk on the recent advances in ART or IVF. It's a very important talk, again, because a lot of time people who are practicing directly or indirectly, they should be knowing about the advances left, because if you don't have much about the knowledge, you can't give much options to the patient. And you know, today the court of law says that you have to explain about everything. So even at a family physician level, if you are directly telling a patient go for adoption, go for surrogacy, or go for anything, and if there are some better options available, then the patient can tomorrow say that as a family physician you misguided, you never told these are the options also available. So a very important topic we have kept to understand what are the options. And we have an eminent speaker, Dr. Pinky Shah. She is a consultant fertility specialist of Arush IVF and Endoscopic Center at Malad and Mira Road. Over to Dr. Pinky Shah, madam. You can share your screen.
Yeah, good evening, everyone. Thank you, Dr. Shukla, for my kind introduction. It's my privilege to speak on the Indian Medical Association platform. My previous speakers have given very excellent talk, and it has been an academic feast. So my topic for today is newer advances in fertility treatment. As rightly said by Dr. Shukla, we all should know about the newer advances, what are the options available, how we can guide best to our patients, and inform them about all the treatment options and modalities. So the journey has been wonderful. It all started on 25th July 1978 when Professor Robert Edwards and Patrick Steptoe, they did the first IVF, and the first IVF baby, Louise Brown, was born. She herself is a mother now. So they rightly said that we are at the end of the beginning and not at the beginning of an end. They had the vision that this is just the starting, and IVF will see a new era and new options later on. The journey has been incredible. We started with a laparoscopic pickup, which was an invasive procedure. Now we all do a transvaginal ovum pickup. It began with IVF. We all now opt for ICSI, which is used for the severe sperm factors. Initially, it was a clinical touch embryo transfer. Now the newer modalities with ultrasound guided embryo transfer, they give a specific point of deposition of the embryos. We look upon OHS's free clinic where we reduce the complications, and we opt for single embryo transfer, reducing the multiple pregnancies henceforth. So this is the overview. In our usual consultation, 1 in 6 couples will need some form of fertility treatment. So now with newer advances, modifications, newer technique, the pregnancy rates are very much high in comparison what it started before. It has become very safe, reducing the risk of OHSS and multiple pregnancies. And now we try to follow the evidence-based practice because the research has been done worldwide and we have much of data to follow. So these are the variables which defines the success of any IVF treatment or any fertility treatment. Main success depends upon the woman's age. Beyond 35 years, the fertility potential of a female drops down. The other things are the profile, the stimulation protocol which we all choose, the clinician and the embryologist expertise, and the lab environment. The IVF lab is the heart of the IVF treatment. So what is the environment? Do we all follow the safety protocols? So there have been many advances in the diagnostic modalities. One of the breakthrough is the ultrasound. When we began, we had a 2D USG machine with limited focus on the pathologies. But now with the advent of 3D, 4D ultrasound, better resolutions, we can see the Mullerian anomalies, the intracavitary pathologies of the uterus, which before we needed a MRI to see those problems. But now the patient can just go through simple ultrasound. We can give a proper report and plan the further management. The further advancement is in the Doppler studies, where with the help of blood flow to the uterine vessels and the endometrial vessels, we can predict the timing of the IUI. We can predict the chance and success of the implantation with the endometrial flow. We can offer other options which can improve the endometrial flow, and then we can choose to go ahead with the further fertility management. So antral follicle count are the number of small follicles from the range of 2 to 10 millimeter, which are seen during the periods, day 2, day 3 of the patient's menses. So this antral follicle count, they are the ovarian reserve marker. They will give you the idea which protocol we have to opt and how we need to go about. So with the advent of SonoVac, the number of follicles are accurately measured, and they give different colors. The report is a very amazing report. When we look upon, they give you the accurate number, accurate sizes, and therefrom you can start up deciding the further line of management. Since past 5 years, the anti-Mullerian hormone, which is a test of AMH, it's a hormonal test. The beauty of this test is that it can be done anytime during the periods. We don't have to wait for the patient to get the periods, unlike FSH and LH. The AMH is the ovarian reserve test. It will guide about the egg quality and the quantity of eggs available for that patient. You can very well tell the patient that how long she can wait for her to plan her fertility, what should be the hierarchy of the treatment modalities which she can choose, the options available. AMH is the gatekeeper. It selects the number of follicle which can be recruited for that further cycle. So with help of AMH, there has been breakthrough in choosing the protocols and how we guide our patients. So initially tubal evaluation, we need tubal evaluation for most of our patients. It began with a traditional hysterosalpingography, which is a painful and an invasive test, followed by laparoscopy, which is an operative test. But with a newer concept, you can do a very well designed 3D USG, predict the problems which could be seen on the hysteroscopy or anticipate them, keep all the things ready in the operation theater. You can combine a hysteroscopy with a laparoscopy. So with this, you can very well guide the patients about the problems which she has and give a further plan of management. The recent sonohysterosalpingography is where we push a normal saline vaginally, and you can look the intracavitary pathology or a free spill. At least you can predict a one tube is patent with the free flow on the sonosalpingography. So how do we improve our IVF success? There are many checkpoints where we can improve, whether with the choice of recent or newer gonadotropins. How do we do the oocyte retrieval? What is the fertilization rate? How do we choose our embryos? And how do we do a embryo transfer, improving the embryo transfer techniques and the lab facilities? So these are the recent advances in ART, the stimulation protocol, the advances in embryology, and I will also discuss about certain future techniques which will be seen later. So when the IVF practice started way back, it was just the one protocol for every patient. But then eventually with the advent of ovarian reserve test, we have come to a conclusion that you can use certain predictors like age, anti-Mullerian hormone, and the antral follicle count with the patient's BMI. You can make it an individualized control ovarian stimulation. Decide your responder. It could be a hyper responder, a normal, or a poor. Depending upon which the patient falls into responder, you choose the protocol. Then you decide if you want to do a fresh embryo transfer or a frozen embryo transfer. This is how you give the best maximum success rate to the patients. So when the IVF practice was started, the patient had to take daily injections in the form of intramuscular form. But now the recombinant patient-friendly injections are available, which patient herself can inject. And in the COVID era times, you can actually pack the injections. Patient can safely take it on herself. She does not have to visit or leave home frequently. In the Western world, in India, this injection is yet to come, but the co-follitramin alpha is the injection, which is a FSH hormone. It has a long half-life. One injection, the effect lasts for 7 days. So this is also a breakthrough in the injectables available for the IVF cycles. When we started IVF practice, there was only one protocol available, which is a long protocol, in which the patient had to take injections much before the periods, and it was a long duration that a patient had to take injection until the pickup cycle was planned. But now with antagonist protocol, the injections are started from the periods. So this reduces the number of injections, the number of visits which the patient has to come, and the antagonist protocol is the choice of protocol for polycystic ovarian patients, where you can use an agonist trigger and safely eliminate the chance of ovarian hyperstimulation. So what we opt for now, we all over the whole world is opting for OHS's free clinic. That in case of polycystic ovarian syndrome patients, we opt for antagonist protocol, where you can safely give agonist trigger. The agonist trigger, unlike HCG trigger, eliminates the risk of ovarian hyperstimulation. So in such patients, do the pickup, freeze the embryos with the vitrification technique, then do the remote embryo transfer in the next cycles when the ovaries are much settled, and it reduces the risk of ovarian hyperstimulation. So we are all moving towards the OHS's free clinic. Now the world is moving towards a freeze all strategy. That is what that you do the pickup, freeze all the embryos which are available, not only the second best. The best embryos are transferred in the posterior cycle, where the endometrial environment is more physiological. It reduces the deleterious effect of the control ovarian hyperstimulation. So there are many meta-analysis evidence-based that frozen embryo transfer results are much higher than the fresh embryo transfer. The whole world is moving towards a freeze-all strategy for our patients. So poor responders are those patients with advanced stage whose egg reserve is much on lower side. Previously, the patients had to opt for donor egg programs, but now we have so many things which we can offer to the patients. They can have the best chance of their self gametes. They can bear their own child before moving to a donor egg options. So protocols available are the mild stimulation protocols, where the oral ovulations are combined with injections. So we have found in poor responders, higher dose of injections don't help. So you can opt for a lesser dose of injections with medicines. Dual stimulation protocols so that you can do a pickup in the single menstrual cycle. Do one pickup in the follicular phase, immediately followed by a second pickup in the luteal phase. So this gives you a better cohort. This is the recent advance which is seen with dual stimulation or opted for poor responder patients. You can also do embryo pulling. That means that do one single pickup, freeze the embryos. Do one more pickup, freeze the embryos. Create a better pool, better number of embryos, so that patient has a better chance pregnancy. Also, one more option is doing freezing the patient's oocytes, then combining all the oocytes and then fertilizing with the husband's sperms, doing the ICSI. There are certain medications, these are adjuvants, these are antioxidants, which are given in poor responder patients about 2 to 3 months prior to what they plan, which is the oral DHA and the androgen gel, which is a testosterone gel. They improve the quality of the cohort which is available for the IVF cycle. So these are the advances in the diagnosis of the male infertility. Previously, we used to manually count the semen count and motility, but this is a computerized program. This will give you a whole generated report about the count, the motility, what is the progressive motility, the morphology. Also, in the blood test of the male partner, you can detect a Y chromosome micro deletions. Depending upon the report generated for the severe oligospermia or azoospermia in this patient, if the A, Z, F, A and B are detected, you can very well counsel the patients. These are the arrest, and there will be no chance of getting the sperms on testicular biopsy. But if they have A, Z, F, C, then there is a hypospermatogenesis. There is a 70% of chance you can get the sperms and patient can father their own child. So sperm DNA fragmentation is a test which measures the quality of the sperms as a DNA package carrier. So who all can benefit? If you offer this test, you do it in the patient with unexplained infertility, repeated IVF failures, repeated miscarriages, or smokers, or who have diabetes. They are a high risk of oxidative stress. Once you confirm that there is a DNA fragmentation, you offer them lifestyle modification, antioxidants for 2 to 3 months, and try to treat the underlying cause. If it is not corrected, the patient will benefit from the doing intracytoplasmic sperm injection in the IVF treatment. So these are the recent modalities where you can choose the best sperms before you perform the ICSI. These are chosen which are morphological normal sperms. So they will give you better fertilization rate and reduce the chances of miscarriages and improve the fertilization, improve the pregnancy rates. So recently a microdissection TISA is the recent advances where you can, the TISA is performed under a 15x to 25x magnification. This improves the chance of getting sperms. There is a lesser tissue injury, and you can remove a very small tissue and improve the chance of getting sperms. And this can be used for ICSI in the IVF treatment. So how do we, what is the timeline for the embryos? Post fertilization, when you choose the embryo for transfer, it could be a day 2, day 3, or a day 5 embryo. Day 5 embryo is a blastocyst embryo which has a higher implantation chance. So previously, when the practice started, the embryo transfer was done at the stages of day 2, day 3. Then eventually, with all the recent advances and the data available, we came to conclusion that blastocyst is a higher implantation potential embryo. So if you choose a day 5 embryo transfer, there is a better physiological synchronization of the embryo and the endometrium. So that is a better talk, optimizing selection of the embryos, which has a better implantation potential. So you reduce the embryo to the hyperstimulated uterine endometrium, and there is a less chance of uterine contraction, improving the chances of implantation and the pregnancy. So embryo quality assessment has been moved from a morphological, what we see under microscope, to the available of metabolomics and time-lapse imaging. In time-lapse imaging, you can see the embryos, there is a whole recording of the embryo stages, and then the best embryos can be selected for the embryo transfer, which improves the pregnancy rate and also decreases the miscarriages rate. So when the freezing protocol was started, it was a slow freezing, but in slow freezing, the tissue is dipped for over a transition of the temperatures. So there was a risk of ice crystal formation and the lower survival when we actually thought the embryos or the tissues. But then vitrification came. So with vitrification, there is a higher cooling rate. And there is that the gametes can be directly submerged in the minus 196 degrees Celsius of liquid nitrogen. So when there is no ice crystal formation. So when we thaw the tissue, gametes or the embryos, you have a more than 98% survival rates, so that you can get your embryos and gametes back. So oocyte freezing is a newer technology. Now it is no longer experimental. It can be offered to the patient who are actually delaying their marriage due to social reasons or due to career options until they find the right partner. This can be offered to the cancer patients before they go for chemotherapy or radiotherapy. It is a very good option for a oocyte donor bank, because then you can do the viral markers of the donors, freeze the oocytes, again repeat the viral marker at interval screening, and that these are the readily available gametes. A well chosen profile can also selected for the patients who are going for donor-like program. So laser came as a very good breakthrough in ART techniques. It can be used for assisted hatching of the embryos, or where we perform embryo biopsy for PGD and PGS. So what is assisted hatching? It's the artificial disruption of the zona pellucida of the embryo or the egg, where you can do the micro manipulation. It can be done with a laser or thermal ablations. It is offered to the patient where advanced age, where you anticipate thick zona, or patients with repeated implantation failure. In this, you facilitate the implantation and improve the pregnancy chance. So laser also has a role in PGD and PGS. Genetic screening you can offer to the patient with advanced maternal age or history of recurrent pregnancy losses or IVF failures, where you can actually choose the euploid embryo and transfer, so that patient has a better chance of pregnancy and reduce pregnancy losses. It is also used for the patient with PGD, where there is a family history of X-linked disorders, chromosomal transmissions, or recessive diseases, where you can actually take a tissue, perform the genetic screening, and choose the best embryo, which is a euploid embryo, so that patient have a chance of a genetically normal child. So when as already mentioned, when the IVF practice was started, the embryo transfer was as a blind technique. It was a clinical touch technique. The clinician did with the expertise. But with the facility of the ultrasound, now we perform the embryo transfer under ultrasound guidance. The embryos are loaded in the catheter in between the air and the media column. So when the embryos are deposited, it is very well showed by the assistant that the point of the 1.5 centimeter below the fundus, where there is a maximum chance of implantation and lesser chance of the embryos moving towards the tubal side or coming out. So this is performed under ultrasound guidance. This is the maximum implantation point, where the point of intersection can be measured by the imaginary lines with the help of ultrasound, and where you deposit well at the best chance of the implantation point, improving the chances of pregnancy. So now the whole world is opting for elective single embryo transfer, because we want to reduce the multiple pregnancies. So in a better prognosis patient which are less than 35 years, you can choose a single best embryo, which may be a day 3 or a best blastocyst at the day 5 transfer, and choose to freeze the surplus embryos. So the surplus embryos with a good vitrification technique can be used for second cycle if the first cycle has not worked for the patient, or they can use the same embryos at a later stage to plan a second pregnancy also. So this is how you reduce the multiple pregnancy rate and improve the cumulative live birth rate from a single ovum pickup cycle. So repeated IVF failures is a distressing thing for the patients and the clinicians. It requires repeated counseling of the patients. What else can we offer? So in this patients now, this group of patients, we have many things which we can offer before we think of further treatment. So there are changes of the protocol selection. You can offer antioxidants, intralipids, which is a form of immunotherapy in the form of IV therapy, where it reduces the natural killer cells of the uterus and improves the chance of accepting the embryo for the patient. The role of GCSN and PRP, which I will be discussing in the coming slides. Here in repeated IVF failures, you can choose the best sperms and the embryo selection, which I have explained in the previous slides. How do we choose with the recent technology available? Also, there is the availability of ERA, the endometrial receptivity assay test. So this test, it finds the best window of the implantation, the right window after the progesterone exposure. The report generated is the receptive and the non-receptive. Depending upon the receptive window of implantation, you can deposit the embryo at the right time, at the right hours of the post-progesterone exposure. If the report is non-receptive, they will give you a personalized embryo transfer window. They will calculate and they'll tell you that depending upon the post-exposure of progesterone, what is the right time to deposit the embryos, so that the endometrium accepts the embryos and there is a better chance of implantation in this kind of patient with repeated IVF failures. The GCSF, it's a granulocyte correlated stimulating factor. It stimulates the neutrophilic granulocyte proliferation and the differentiation because it acts on macrophages of the decidual cells. So how does it contribute? It contributes to the reproductive success by improving implantation, improving the blood flow to the uterus, improving the endometrial thickness so that there is a better endometrial thickness at the time of embryo transfer. It reduces the unexplained repeated pregnancy losses when we give the subcutaneous granulocyte stimulating factor from the time of embryo transfer till 12th week of conception. It enhances the endometrial receptivity and the endometrial thickness. So recent, the platelet-rich plasma has been proposed. This is a proposed treatment for the endometrial rejuvenation and the ovarian rejuvenation. The patient blood is collected, the platelets are separated, and this extracted platelet-rich plasma can be deposited in the uterus to improve the chances of pregnancy. It improves the blood flow and the endometrial thickness. They can be injected in the ovaries in the form of ovarian rejuvenation for the patient with ovarian failure and poor ovarian reserve. This technique is still under research and we are waiting for the correct data until it is implemented on a regular basis. So the past 2 months, whole India is doing the cancer awareness program. So many communities have come up for the cancer awareness program. So it's a duty of the doctors that we need to inform our patients before they go for any chemotherapy, radiotherapy, or a surgical procedure that there are techniques available to preserve their fertility for the further planning whenever they want to plan pregnancy, when they are fit for the further health perspective. So techniques available for the female are oocyte, embryo preservation, the ovarian tissue preservation. Also the in vitro maturation can be done so that patient can have their own gametes and they can have their own genetic child. Techniques available for the males are the sperms and the testicular preservation. We need to tell our patients that they can start the IVF treatment at any duration of the menstrual cycle. Previously, it was thought that they'll have to wait for the menses, then they can start the IVF cycle. But now the theories of follicular genesis has come. There are multiple waves of follicle recruitments. Maybe 2 or 3 cohorts of antral follicle can be seen on a various stages of the menstrual cycle. So patient, irrespective of their stage of menstrual cycle, they can just go ahead with they can start with the injections and they can go ahead with the ovum pickup, freeze their oocyte or embryos depending upon their partner availability before they go for surgery, chemotherapy, and the radiotherapy. So this is what we need to counsel all our cancer patients once we see them in OPD, that these are techniques available and they can choose if they want. So what is a 3-parent babies? When the mother is suffering from some abnormal mitochondrial genes, this can lead to myopathies, epilepsy, stroke, hearing loss, or retinopathy in their next generation. So in 3-parent baby, the affected woman's nucleus is removed and inserted in the enucleated egg of the healthy woman, which contains her mitochondria. So now the child belongs to 3 parents, the patient, the donor egg, and the husband. So the concept of 3-parent babies was introduced. So now we are looking for creating new generation embryos. We will screen for aneuploidies. We can test for viability markers, culture in safe media. So there is no alteration in the gene expression. You can culture in stable and controlled conditions and a use of reliable witness system. So now the era of a new generation embryos will be seen in some due of time. So what do we have stored in our future? The future looks very much promising, with the surrogacy bill being in the gray zone. If it is not being continued in India, so that the options available are the uterine transplantation, where the first uterine transplantation was reported in USA in the year 2013, and the India had a privilege from the doctor team from Pune gave the birth to the first child in India with the process of uterine transplantation. Also, we are looking at stem cell therapies where we can generate male germ cells in case of azoospermias patients. Also, the stems can be used for generation of ovarian and oocyte tissue and the endometrium regeneration. So stem cell therapy would be a breakthrough where the patient can have their own gametes and they can opt for their own embryo transfer in their uterus before moving to uterine transplantation or surrogacy. So this is a technique which is a CRISPR. It is a gene editing technique where this can be used to alternate DNA sequence or modify the gene functions. This can be looked upon a breakthrough where we can modify the genes available and create a newer gene sequence in the couple or the embryos. So Aldous Huxley in the year 1932 had actually predicted IVF as a science fiction. Now we have seen IVF as an accomplished dream. He also had predicted exogenesis, which was the development of the conceptus in vitro completely outside from the body till the period of viability. So this is yet to come, but maybe we'll see this era later on. So where do we, to complete my talk, where do we stand now? So now we look upon safety, where we have fewer twin pregnancy from 1992, decreasing the the OHSS risk from the year of 2000 when the antagonist protocol with agonist trigger were introduced, higher pregnancy rates because of the evidence-based practice and the improved lab and the recent advances, and better neonatal outcome. So we are aiming for a healthy child to a healthy mother. So with all these advances, we also will have to, there will be need of a proper consents, proper documentation, where the patient has to be informed about the options available, what are the chances if they don't opt for the options, and what are the pros and cons of each procedure. So this we will need to inform our patients in a detailed manner. I thank you all for your patient listening.
Thank you, Dr. Pinky, for detailed presentation and making aware the audience about the advancement which has happened. And it becomes very important because the amount of options now the patient has is huge compared to what it was there in before. And now if the patient is willing to go take treatment, spend, then a lot of things can be avoided. Even if the patient is having high chances of abortion in the past or abnormality in the past, it can be use advanced techniques by which we can avoid this. And the most important thing I remembered a lot before, one of the family physician gave me a call and told, doctor, I have a CA breast patient and she is just going to get chemotherapy and operated, but she is married, whether we can do anything. And we were able to send to Dr. Mukesh Arush, and we remove her follicles, eggs, and then we created embryo and freezed it because she was married, and became very important because once I operated, chemotherapy done, then a lot of things have already been gone. So it's very important that each and every doctor should be aware about the options available, because if you don't give those options to the patient and tomorrow patient feels that there was something which could have been offered, which could have saved me from my future issues, again you will land up with legal litigations where patient might say, I was never told or never informed. These options are there, irrespective whether I'll afford or not afford. A lot of time doctors feel whether the patient would be able to afford or not afford. Law says ki you give an option, it's patient's choice. If patient doesn't, that's patient's decision. You can't pre-plan or pre-think or pre-decide in the name of the patient that I thought the patient is poor, so the patient might not go, or I thought patient is poor, that this test patient would not do, and there is some abnormality. So it's a very important topic, very nice talk, madam, very elaborate, and I thank you, madam, for this. And I think so we will take question answers. A lot of question answers are there. Dr. Gitendra Sharma is traveling, and that's the reason he is having some issue with the net connectivity. He has gone to Pune. He's in AFMC for his son's admission and interview. So in Pune, there is some part where there is network issues. Dr. Naurange sir also was having difficulty to join in, and then he went to IMA Pune office, and then through IMA Pune he joined because the net was good there. So he has some net connectivity issues. Still he joins. I think so. We will take the next speaker, Mr. Dipen, and then we will discuss the question answer till the Gitendra Sharma joins. So thank you, Dr. Pinky. So over to Dipen. Mr. Dipen is, I think so. He is. We have heard him in the past also. He is an excellent person who is a CEO and carries long experience in operating and controlling the critical business process in the field of financial and the healthcare, and mainly about digitalization, because we doctors are not that good in digitalization, and now digitalization of records are very important during this COVID, and not only this, for storage also. So let's see what Dipen can offer. I think so he is going to speak for around 3 to 4 minutes, and then we can take the question answer session till Dr. Gitendra Sharma joins for our last talk. Over to Dipen.
Thank you, Dr. Ashok Shukla. Thank you, IMA Maharashtra, and Meera Bender for giving DigiShield as an opportunity to manage the webinar. I will not take much time of the delegates and speakers. I will just let you know in short like what is DigiShield and how DigiShield can help doctors to maintain their medical records and safeguard for their medical legal as well. So we have various other features in DigiShield. Doctor can do teleconsultation, video consultation. Doctor can get digital consent of their patients before the consultation. Doctor can even get consulting fees through online through DigiShield. Doctor can upload their patient prescription, medical records, and entire medical history can be maintained in one go. And DigiShield is very easy to use and it's very handy to use. Doctors can also get the reports of their patient, the number of times the patient visited, the patient's previous history, what was the patient's previous medication which doctor has prescribed. So currently what doctors are used to prescribe the medicine with their traditional method of writing the paper and on the prescription pad and give the hard copy to the doctors. So instead of giving the physical copy to the patient, many times patient forgets to bring their hard copy or physical prescription for their follow-up or next visit. So instead, if doctor has write the prescription on the pad, they can click the photo, they can upload in the application, and patient will receive the soft copy of the SMS through SMS link. So even patient forgets to bring their prescription for in the next visit, doctor can view his previous medication or previous prescription what doctor has prescribed to the patient. In also currently what doctor is doing video consultation through WhatsApp. So in such cases, what happens that if a doctor has done a video consultation through WhatsApp and has sent the prescription in the WhatsApp, and if patient doesn't pay the consulting fees, or doctor or patient forgets to pay the consulting fees, so it's a risk for the doctors to ask the patient or to remind him for making the payment. So through DigiShield, if doctor has done a video consultation through DigiShield and doctor has sent the prescription as well, and if patient doesn't pay the consulting fees, patient will not able to view the prescription unless and until patient pays the consulting fees. If patient opens the link through the SMS for the prescription, patient will be prompt to make the consulting fees first before reviewing the prescription. And it's very easy to use for the doctors, and it's free for the doctors for the lifetime, and it's available on Android and iOS both. So would recommend doctors to start using DigiShield and start digitalizing their medical records and start doing a video consultation through DigiShield if they are doing in WhatsApp or all. We can always happy to help the doctors and have their clinic or their prescription completely digitalization. If you have any queries or any issues, you can always reach to us. You can also visit our website www.digishield.me. Thank you. Hand over to Dr.
Yeah,
Ashok.
thank you, Dipen, for helping our members and telling them that we have a very easy way also of getting things digitalized, where we can use a digital prescription on a click and also store the indoor papers later, scanning and everything. It's a one-stop. So DigiShield are our academic partners for all the webinars. At present, what we are doing in the medical legal cell for the points, so whoever are interested, they can directly go on the app, they can download. There's a lot of information there, and anything they can contact Dipen. He is very helpful and guiding. So I think so we will go to the question answer session till the last speaker is able to connect. Dr. Gitendra Sharma, as I told you, he is in AFMC Pune. So there are some interesting questions, and we will start from the last question and go reverse wise. So the the last anonymous attendee is any update on CME points. So CME point is there. Everybody, whoever attends, we give a digital attendance sheet to the Maharashtra Medical Council, who assess the number of amount of times the person has attended as per the MMC guidelines, and they credit the point in the doctor's account, whoever has followed as per the guidelines. Then Dr. Abhijit has asked, if we are employed in a hospital and if I found any deficiency in the instrument from the hospital, if I WhatsApp him or use any other digital platform, will it stand in the court of law? Dr. Naurange sir, if you are there, I think so. He was there. I just spoke to him. I'll just, sir, unmute yourself, Dr. Naurange sir. Anybody from the panel also can answer. Dr. Dinesh Thakre sir, Dr. Mohite sir, Dr. Naurange sir is just joining. I'll just give him a call because, yeah, he's joining because it's a very interesting question and it can happen with anybody. Because if you're employed, a lot of time, see, I always tell people who are visiting consultants and who are doctors who are attached to multiple hospitals, learn to ask and verify because you should also see the other things in that hospital, whether the license of the hospital is renewed, whether they are following all the government norms. Nothing should not happen that you have just been called, you go there, operate and come, and later you come to know they are not following, they don't have a proper environmental, they don't have MPCB, and then suddenly you say, Doctor, I thought everything is there, and they called us because everything is supposed to be displayed in the waiting area. So when you also enter in the hospital, you should see that waiting area, that whether these things have been displayed or not, and whether these licensing are in place, because ultimately if it's not there, you also would have a contributed negligence that you didn't know you have indirectly operated in a hospital which is not registered. There are times when people, the hospital owner has not renewed the registration and there is some litigation going on, they has not applied also, then these issues can happen. Dr. Navaranga sir, you have joined? Yeah. Sir, a very interesting question is there. If we are employed, Dr. Abhijit has asked that if we are employed in a hospital and if I found any deficiency in the instrument from that hospital,
Yes.
and if I WhatsApp him, the consultant WhatsApp the owner, or use any other digital platform, whether it will stand in the court of law tomorrow to support that I had informed and the person, the owner had not rectified.
Yes, it would. Yeah. It would amount to that. परंतु मला असं आय थिंक दॅट मराठीत बोलतो फक्त की सर्वसाधारणपणे असं धरलं की लेखी द्यायला पाहिजे. आय नो देर इज इनिबिशन टू गिव्ह इट सबमिट एव्हरीथिंग इन रायटिंग. सो व्हॉट यू कॅन डू इज टॉक टू देम इन पर्सन आणि त्याचे मिनिट्स काढून त्यांना पाठवायत मॅनेजमेंटला की आज आपलं असं बोलणं झालं. आय थिंक दॅट इज इनफ. आणि सेकंड थिंग इज दॅट इफ यू कॅन राईट एन ईमेल दॅट इज बेटर दॅन व्हॉट्सअप, विच इज अ मच मोर ऍक्सेप्टेड वे ऑफ ऑफिशियल कम्युनिकेशन. सो दोन गोष्टींनी, कारण काय होतं आता माझ्याकडे तुम्ही बघितलं असेल व्हॉट्सअप तुम्ही पाठवलं, एव्हरी टाइम आय डोंट चेक द व्हॉट्सअप, तर त्याला थोडंसं हा अनसर्टनिटी राहते की युअर इट्स नॉट अंडर ऑब्लिगेशन दॅट आय मस्ट चेक व्हॉट्सअप एव्हरी नाउ अँड देन. त्या दृष्टीने ईमेल पाठवा, डायरेक्टली फोन करा की मी ईमेल पाठवला जरा बघा फक्त.
And the best thing, sir, you told is the email, because every hospital normally has their own registered email ID on their file or when you join in the corporate. And the advantage is that if you directly email, it goes to that and it comes in the record. And in fact, it doesn't listen. You can send a reminder also. Sir, this is a reminder. And second thing, if you feel that that's something which can danger the patient's life, then you should refuse. See, ultimately liability is going to be you. Tomorrow the court will ask, when you knew that your owner has not rectified, why you continued operating?
Sir, अशीच एक केस माझ्या वाचन, म्हणजे ही माझी तर प्रत्यक्ष केस, मी आय टोल्ड यू अबाउट दॅट पर्टिक्युलर केस, डेंग्यू शॉक सिंड्रोम. That is a real case, but judgment just came after that from Supreme Court, saying that this doctor was informing the management again and again, and even then corrective actions were not taken. Ultimately, he left the institute, but this is what has resulted in the damage to the patient, and therefore the management is totally responsible. I think that's a very important point, that you should make a very polite representation that these facilities are required.
Right, sir. Next, again, Dr. Abhijit Rayate sir had asked, patient operated, patient suffered means maybe some complication. Yes. The patient sues the hospital and the doctor. Yes. What is the role of the anesthetist?
If there is an anesthesia complication, see, anesthetist becomes a necessary party in every operated case. If the complication has occurred in the operative part, or operative period or immediate post-operative period, till he is not out of the recovery room. So anesthetist liability is up to the shifting the patient to the regular room. So if something has happened due to anesthetist problem, he is equally liable, even if he is not included in the case by mistake by the patient. We should insist that this is the important essential party to join in the suit.
Yes, and anesthetist helps the doctor to defend, because a lot of time whatever you have done, anesthetist sometimes is treated as a third party, not directly person against whom the patient has complained. And then anesthetist can also tell ki, yeah, doctor has done this, we were there, and things become more. So that is the important role of the anesthetist.
Very important.
As sir told ki, proper documentation has to be there. People have to mention who was the anesthetist note should be there. and the anesthetist, because it should not be that there is no mentioned and then the problem occurs. Then
And now NABH says that he should have an independent consent also.
Yes, yes, yes. It's very
Consent
important.
for the anesthetist is required.
Yes,
So
it's very important. Yeah.
And I would say that as far as surgery is concerned, anesthetist is the physician's control over the surgeon. In short.
Yes, sir. Yes, sir. Very important line. Now, Dr. Wasim Sheikh has asked again a very interesting question, sir. What if there is a death of a neonate in a hospital due to malfunction of a baby heater, maybe warmer, he's trying to say, which has been examined and certified okay by a technician? Whose liability is this? It's really sad that a life is lost.
So this has happened. This is an actual case.
Right.
Budwarpet in Pune in 2018.
Okay, sir.
Case. The machine was supplied. The heater was supplied from the infant warmer was supplied from some company in Chennai.
Okay.
And the at the end of 1 year's warranty period, nearby the warranty period, the technician had come representing the company. He maintained there was no fault. He maintained that particular machine. Next day was a cesarean, and then there was a blast of that particular instrument, and the child charred to death. This was a terrible situation, and this is a very big case, and this could be primarily the responsibility of the hospital as well as of the doctor, because he has got the instrument from somebody, but ultimate liability he can shift to the manufacturer.
Yeah.
That ginger beer case.
Yes.
It is something like that. Ultimate liability will be that of the manufacturer, provided he is functioning. In that particular case, the manufacturer had closed down his business, and it was a passing by company. So I don't know what has happened ultimately, but the case is going on.
Yeah, and yeah, very important, sir. And in the recent CPA, now the Consumer Protection Act, the recent, now they have something called as product liability also. So it becomes very important, but the only thing is the doctor should have the original bill of purchase. He should have the service contract. He should be able to document that if the company has told this time the product has to be serviced, it has been done. If the power supply, what the company has told, has to be this way. Otherwise, what the company will try to take the benefit, because ultimately they will also be having lawyer. So they will try to say the product was not used properly. All those guidelines, what we have written in the format, has not been used. The meter, the heater, the sensor was not placed, and then again it will shift to the doctor. So doctor has to take more responsibility and care. And so even if there is a good, properly functioning instrument, the staff is the best person who should be trained to pick up these warning signs and some issues, and to protect at least the life and to limit the damage done to the patient or the child. Ultimately, liability and how much damage has occurred, but losing a life is something which is very...
It's a terrible situation. I agree with you, sir.
Right.
And don't go by, as far as medical instruments is concerned, I would say don't purchase online. You check the instrument yourself before taking the possession of that instrument. So some reputed company. So just go by online. It is not that simple.
Yeah, it's always buy better and spend slightly more on your instrument, instead of going for a very cheaper one and something which is new in the market, not time tested, at least when you are using for your patients. Right, sir, right. Again, a very interesting question. Dr. Nitin Toraskar sir has asked, can government doctors be sued in consumer court?
This is a very tricky question. Not directly, they should sue the government only, government hospital. So in turn, the government hospital will take the answer from the doctor concerned. I don't think they can be sued directly. No.
Right, sir. You're right, sir. 100% they cannot be sued directly. You have to file a complaint against the government itself, and then the government. Then Dr. Ravindra Kute sir had asked, cancellation of registration is common threat given by police, patient, relatives. Is it so simple weapon? But I think so. Dr. Utture sir in the beginning had told our members that don't worry, we are not going to unnecessarily suspend or cancel, and except them, nobody else can blackmail you of cancelling or suspending your registration. So I think so, yeah.
I would just add a little. Dr. Thackeray rightly said about the PCPNDT Act, which is a central act. Now Maharashtra Medical Council has got it clarified from indirectly from High Court that they can give graded punishment, but a council has limited power to give graded punishment, in the sense that it is the warning, temporary suspension or a permanent suspension. Even warning is a problem, sir. I tell you why. in one, I mean, there are many cases, Dr. Uttare would be surely knowing about it, that on a simple mistake, writing mistake, in Pune, there was a havoc from 2012 onwards. So the doctor got a warning because there is a case against him. Of course, the things have improved afterwards. But necessarily, second time, if, sir, Dr. Uttare, you can correct me if I'm wrong. Second time, if similar cases, they're very small mistake. It's very difficult to interpret whether it is a mistake or not. The next level is not warning alone, but it necessarily is temporary suspension. So about medical council in Maharashtra, it is okay. Temporary suspension, then warning and permanent suspension. In other states, I'm afraid it is not being followed, number one. And what the doctor is more concerned about the graded punishment is the severity of punishment of jail and fines and all that. So over there, they are not applying. And unfortunately, the Foxy, this thing has failed. Petition has failed. So that problem is section 3 and 4, where, as rightly pointed out by Dr. Dinesh Thakre, that any deficiency or deviation, any word is very important, is taken by law as criminal liability. So that is the problem. And that could not be improved. So now we are stuck up.
Yeah, Dr. Shukumar Uttare sir from MMC, you also wanted to discuss some questions connected to PCPNDT talk, because that time we were positive of time. So we thought we will take at the end time. So that's the reason.
Yeah, see, basically, I just wanted to make some statements. See, what you have to understand is why this PCPNDT Act came at all. If you see, and plus this Act is a very old Act. It was not implemented till it got implemented after the census of 2011, when they found there was a gross discrepancy between the male-female ratio. So we cannot absolve. When I say we, I mean the medical fraternity cannot absolve ourselves, saying that this is just a social evil, because we have been part and parcel. When I say we, it is not all of us, but some of our members have been part and parcel of getting this sex ratio,
aberration.
So unfortunately, because of a handful of people, the rest of us have to suffer that. But as I said, that you cannot have a specific laws for specific people. It is law is across the board for everybody. And this I'm saying because I have been quite passionate as far as this PCPNDT Act is concerned, and especially sex selection is concerned. Even I was in charge in the last council as far as this Act is concerned. And in the beginning, I have had a lot of arguments and fights with the authorities. But then, every time we used to have this argument, they used to throw the book at me, giving the statistics of how many doctors are really involved. So even a simple thing like I'll tell you, our doctors went to the extent of having mobile USG clinics in the fields, in between the crops, so that they may not be caught. They were, just like how you see PUC cars at the end of a highway to do a PUC. Unfortunately, our doctors have kept their USG in the vans. And therefore, see, all these backlash comes in when a few of us do things which we were not supposed to do. Yes, there are a lot of provisions in this Act which are not proper, I agree, which a lot, and just like how Dr. Thakre said, it is always the good doctor who follows everything who gets caught because he does not pay attention to the details. And the person who is actually doing the Sex Selection Act sees to it that his paperwork is absolutely, spick and span. And that is why I keep on repeating that paperwork is the only thing that is going to either dupe you or save you in the court of law, because that is all that is seen over there. So that is the importance of, what this PCPNDT Act is there. And second thing, as far as what Dr. Naurange was saying, Dr. Naurange, you have to understand that unfortunately the Act says that some punishment has to be given to them. And instead the Act says that you have to suspend them. Now, luckily for us, we had those good judges over there, and they gave these, this is that famous Ramineni, and the other case I don't remember who that doctor is, but Subhash Singh and Ramineni Solanki case, in which we got this, we got this clarification from the High Court, saying that we as MMC should act as per the MMC Act, and that's where we got the we got the provisions of taking action against them, which was graded. And as per the MMC Act, the minimum punishment is warning. So that is minimum, we have to give them a warning, and that is what we have been doing up till now. And let me tell you, in a lot of cases after that also, where we find that there has been just technical errors, we have not even given them warning. In a lot of cases, we have said that where there was prima facie evidence that they have done wrong, but it was still, the case was going on in the court. We gave in between a judgment saying that, okay, like for instance, a gynecologist, you continue doing your gynecology practice, but you should not do ultrasonology practice till we get the decision from the court. So that, our members could go on, at least, radiologists should do any other radiology, but should not. But unfortunately, they did not understand why MMC took this type of a judgment. And one of the radiologists did the most stupid thing of going to court against us for giving us, saying that don't do radiology, but don't do USG, but you can do the rest of the radiology. And there the court came down so heavily upon her, and then indirectly came down heavily upon us also, stating that as per the law, you do not have that jurisdiction to say that you can do, other than sonography, you can do rest of your practice. They said, if you are going to suspend sonography practice, you're supposed to suspend them completely. Unfortunately, that is a judgment that we got in our hand, and then we had to act on that. And of course, we had to suspend that person after that completely. I don't know what stupidity they did and went to court, because we were saving a lot of our members that way, where we used to tell them don't do sonography. So many a times, what our members should get into the habit is, before listening to pure lawyers, a lawyer always sees what he can present in case, and then he'll always tell you that you will win this case. He'll tell you, I will fight for you. Not only that, in PCPNDT, in the beginning, when we were in the beginning of this PCPNDT problem, we were fighting that, when we were finding that whenever charge sheet used to be filed, the lawyer used to say, okay, let the charge sheet be filed, we will fight it out in court. Now that takes years, but he wouldn't understand that once charge sheet is filed, the counsel comes into play over there. So, of course, I shouldn't not have been doing that in the past, but in all my talks with all our IMA conferences and all, I used to insist that once that you are caught in this problem of PCPNDT, you challenge the charge sheet itself and get a stay on the charge sheet. As soon as you get a stay on the charge sheet, the counsel does not come into play. You understand this legal point. I think you all will understand, but all the members should also understand this point, that what you require to do is not fight it out afterwards in the court once the charge sheet is filed, but what you require to do is to challenge the charge sheet itself and get a stay on the charge sheet, so that the counsel is not involved in that. Once the charge sheet is filed, as per the act, the counsel gets involved, and some action we are unfortunately supposed to take. And that is what we have been doing. But unfortunately, if you see that it is some of our members, and that becomes a very bad publicity in the papers also. And therefore, the government becomes more tough and asks questions to MMC also. If you see recently in that famous bead case, what is Dr. Munde? Dr. Munde was caught red-handed, and we suspended him for 5 years. And still the 5 years period is not over, and he was already practicing and doing the same thing. So what happens, such cases which come up, they spoil the name of the whole fraternity, and unfortunately then we have to start taking action on even other innocent doctors, because they have made some technical mistakes in that. And unfortunately, another thing you have to understand, even in the original committee which formulated this PCPNDT Act, unfortunately, there were members of the doctor community, both Foxy and IMA, who were there in that committee. Even today in the state committee and in the central committee, there are members who are sitting over there. And when, I inquire why things are not changing as per what changes we want, surprisingly, the answer I get from the authorities is, तुमचे लोक जे तिकडे बसलेले असतात ना, ते तोंड पण उघडत नाहीत once they are sitting in the meeting. So this is the unfortunate part that is happening. We have to have activists who really go on to such committees and who are sitting in that committees, who can, argue from law point of view in these committees of why these changes are required. We cannot be emotional when we are talking about law or when we are talking about acts. We have to talk legality of the whole this. So we cannot say that you cannot punish 100 people just because 10 people are doing that. That does not hold true in law. So I think if we can start changing that, and the state IMA and the Foxy, and unfortunately, as Dr. Naurange said, Foxy unfortunately lost that case. And that was a big blow as far as PCP NDT is concerned. And therefore, we are stuck with this act till we can convince the central government. This is a central act. This is not a state act. Remember that. This is a central act. So we require to convince the central government that we require to make these amendments. And if we can do that, and maybe now slowly we are finding that the sex ratio is, slowly coming up. It's not that it's not yet that skewed as it was before. Maybe once we come to a stage where it comes back to normal, then we may be able to convince the government as far as this act is concerned. Till then, we'll have to wait and watch.
Okay. Yeah, point taken, sir. Very nicely elaborated. So I think so. It's already 5:30, and I just received a call from Dr. Geetendra Sharma, who was the last speaker. He's stuck in AFMC Pune, not able to get any network there. From last half an hour, he's trying to get an angle where he can get good amount of network so that he can give his presentation from his cell phone. But then he has apologized. Mostly after 15 days again, I will be having one MMC point 5 speaker program. In that, he has already accepted my request that he'll give a talk there. So I think so we'll take the question answer session, and then because already it's 3.5 hours, we have IMA Dombivli program going to start, which is away in next half an hour. So I think so we have 5-7 minutes more. If you people want more questions to be discussed, we have an excellent people there. Dr. Shivkumar Utre sir, MMC president, from 2 o'clock to 5:30, sir. Hats off and salute to you, sir, for supporting our members and guiding for each and everything and trying to understand. And that's the reason Naurange sir mentioned that all states are all not lucky to have such council people there who are there thinking out of box also, that how to help our members and support them and at least cover them from these technical issues where they are unnecessarily get harassed. So thank you, sir. Anything else, or we'll close the session? Dr. Dinesh Thakre sir, you want to ask anything? There is one or two in the last, or I think so we'll close because there are one or two questions on criminal negligence. We are going to have one separate talk on criminal negligence by a very eminent speaker in one of the coming, where we can discuss about the criminal negligence. So thank you. As Dr. Pankaj Bhandarkar sir is there, or I'll give the thanking you. I think so he's not. So I thank IMA Maharashtra State President Dr. Avinash Bondwe sir, Dr. Pankaj Bhandarkar, IMA Maharashtra State Secretary, Dr. Shivkumar Utre sir, Maharashtra Medical Council Chairperson, NMC cell member, and IMA strong leader who is always stood up with us from starting to end in each and every webinars, and not only in this, in the real problems also. Here we are discussing about the problems which could occur and fictitious cases sometime, but in real cases also he is always there and helped us. Immediate past President Dr. Hosi Kapade sir, Dr. Ram Krishna Londe sir, President-elect IMA Maharashtra State. As already Dr. Naurange sir told that we have two Utre sir, Shiva Kumar and Shiv Kumar. So Shiva Kumar sir from Karnataka, Dharwad, legally qualified doctor who always is there in all our webinars from Karnataka, joining and helping and guiding our members. All our speakers, Dr. Pinky Shah, Dr. Jayant Naurange sir, Dr. Dinesh Thakre sir, Vice President IIM Maharashtra State also, and an excellent orator who gave excellent, I think so, 1 hour, 55 minutes to 60 minutes on so many recommendation changes. I think so if the government people see, they feel अरे नवीनच act काढावं लागेल. सगळ्यामध्येच काही ना काही we have there, we can amend it. But I think so, as Dr. Utre sir told, ki people with legal background and medical knowledge should try to, because ultimately I accept sir, when these committees are there, they come out with so much legal words and legal jargon. As you told, ki sex determination is still happening, and how you are telling that act should be repealed and we all doctors are good. Then why this is happening? Why the ratio is not improving? They sit with statistics and facts And then it becomes very difficult for us because we don't have, because our doctors don't give reports, don't found, and then we are not able to fight with them because they say this is the death rate, this is the mortality, this is the ratio. Now you tell me if this act has been really implemented with this spirit, why it has not changed. Then thanks for Dr. Mohite sir, Shailesh Mohite sir, who spent and answered all of our questions on one very important topic, because ultimately if there is any loose line or directly written also that this doctor has had a negligence, sometimes can become problem, because then the police people feel that already this doctor has been told. आता गव्हर्नमेंटचे डॉक्टरने सांगितलं आहे नेग्लिजन्स आहे म्हणजे आहेच, आता काय डॉक्टरांकडे पर्याय नाही, आपण डायरेक्ट त्यांना उचलून घेऊन येऊ. Sir, they start feeling in that way. So there are a lot of things which has to be balanced even in this committee, which are where doctor, they sometimes try to use neutral words, so that people don't misinterpret and try to at least indirectly try to help our doctors. Ultimately, things will go to the court of law, and it is going to be debated from both the parties in the court of law. And the pain for our academic partner DG Shield, and Pinkisha madam for the advancement on the IVF, because as I told now, patients are well aware, they go to Google, they come up, and as a doctor, if we don't give much options to the patient and we say, Ata baba, ekdam low sperm count hai, you don't have any option, you can't become, then the patient will come and to you saying that I had an option, you never told. And I always tell my doctors, give them whatever options are available. Don't feel whether they are affording, not affording. Let them decide. If they are not affording, they themselves will say, I will not. But on paper document, all options has been given. All my attendees who attended the webinar, IMA, stalwart, national and state leaders who were there, Dr. Padma Iyer, the list is huge. I would thank everybody in the panelist group and in the attendees group who came and motivated and boosted us. We will be every Friday. But the problem is, as I had told in the last seminar, next Friday is Diwali. So I don't want people to 12, 13, 14. So that's the reason I have kept in the next week on a Wednesday. So I am not going to miss any week. Every week, one talk is going to be there. So next week will be the Wednesday evening, 9 p.m., where we are going to discuss issues faced by clinics, polyclinics, and hospital owners who are running small nursing homes or setups in pure residential complexes. ते एसीचं पाणी पडतंय, ते एन्व्हायरमेंटचा कचरा टाकून, how they harass and what are the court judgments which come in their support, whether they can practice so that their stress reduces, because see, doctor has too much stress. They are practicing, they are hospital owner, they have to satisfy their society people also, keep answering them. So it's again a very important topic, and after that 20th of November we'll be having in the afternoon. So thank you for being with me. I end the show at the webinar. Jai IMA, Jai Maharashtra.